So we are live in 3, 2, 1.
Namaste and very good morning to all the participants, all the invitees. Very good morning to today's guest speaker, Professor Dr. G. Mohangopal sir, former Director of the National Judicial Academy, Bhopal. A very brief introduction is Sir has been former director, he is a former director of the National Judicial Academy, Bhopal. Sir has been associated with the judicial and legal education since more than 2 decades, I think 3 decades. Yesterday, we started these sessions. Yesterday, we discussed the concepts of securing justice. How do we understand the Constitution? How do we understand the justice? How do we understand the rule of law? And today, we will be on the topic of securing justice, institutionalizing QRTE means quality, responsiveness, timeliness, and efficiency of courts within the existing constraints and role of presiding officers. I once again welcome you, sir, for this session. I also welcome all the honorable justices who are attending this webinar. Sri Lanka, Nepal, India, and all honorable directors of the judicial academies and all honorable registrar generals, registrars of the honorable high courts, all the principal district judges, family court judges, and all other court judges, public prosecutors, principal magistrates, and members of juvenile justice boards, students, staff members, and all. I invite all, I welcome all of you without spending much time. Now I request this guest speaker to take over the session. So once again, welcome and hand over the session to you, sir.
Thank you very much, and Mr. Yarlagada, and very good morning to all the honorable judges. Yesterday, I was delighted to read after the session over 250 comments and questions which came from the honorable judges. I've sorted them out into 11 areas. And I'm going to deal with them at the end of our session because hopefully some of these would be covered by the time we finish. But I'm happy to say that the largest number of questions and comments were on the conceptual issues of justice. So that means that there was a lot of interest in discussing the thoughts that we shared on how to understand justice and the Constitution. So that was the one big area. And our second, almost equally, slightly smaller, but another big area was how to apply this concept of justice, or how to secure justice in applications. In fact, that is what we will focus on today. And then there were also some conceptual questions on the role of courts, adjudication versus justice. What is exactly the role of courts? Again, from a practical point of view. And the next 2 or 3 issues that on themes were how justice can be reconciled with rule of law, court management issues, how the interface between justice versus law, consistency and subjectivity, reasoning, and the relationship between justice and society and morals. Now the issues are getting smaller. Compassion, there were 4 comments on the issue of compassion, and then there were a couple of other miscellaneous comments. So we can see that the main interest of the group is around understanding, is conceptualizing what is justice. It is probably the most important issue in the judicial and legal system because we haven't examined it in detail, and we have started that process, but we need to be clear about it. The medical science has given doctors a much stronger framework to define what is good health. Just as doctors are concerned with the core question of whether someone is healthy or not. And health is the core issue that the medical system deals with. As we suggested yesterday, the justice system is the core concern of the justice system is right conduct, And I've given you a simple understanding that because of the word use, I'm not giving you my own sort of personal view. I'm giving you a basis for that view. The word use means the value of right conduct, the value of right conduct, and therefore justice refers actually to to right conduct. If you want to define it in two words, it means right conduct. Then the question is, what is the benchmark? And I'm submitting to you that we must find that benchmark in the constitutions of India for Indians and for other countries, and in the constitutional history of other countries, because the constitution is actually the foundation of the creation of a nation state. For state officials and all those who work with the state, the constitution becomes the main document. Now, the constitution we mentioned yesterday has two sides to it. One side is its governance side. It creates power, it vests power, it allocates power, it limits power, and that's an important function of the constitution everywhere. But we also know that jurists have always referred to the constitution as setting out the Grundnorm. And so for the justice system, not for the legal system as a whole, but the justice system, because justice is concerned with use, J-U-S, that's why it's called the justice system. And J-U-S simply means the right value. And therefore the justice system is concerned with the norm, the standard of right conduct, because the purpose of the justice system as a subset of the entire legal system is to uphold right conduct. Now that right conduct may mean, and I've based on several years of working with thousands of Indian judges, my hypothesis is that most Indian judges understand right conduct as in around two themes. One is they believe that right conduct is that everyone must get what is due to them. And so when they decide, that's a very overarching consideration in their mind, that they must get what is due to them. That is right conduct, making sure that everyone has what is due to them. It's a distributional idea of justice, which is also there in jurisprudence. The second big idea of justice, which I find applied in the application of and the actual decisions of Indian courts, is the idea of order. That order must be maintained. That there should not be disorder, whether inside the family or in the state as a whole. Order should be maintained. Now, so conduct that maintains order is seen as right conduct. Conduct that disrupts order is seen as wrong conduct. And that is why many judges, in fact, until 1964, every single Chief Justice of India had been appointed as a judge by the British in the colonial period. It was in 64 that for the first time a Chief Justice of India was appointed who had not been a High Court judge under the British. So for a long time, the same attitude prevailed in the Raja era and the Raj era, that there should be no disturbance, order must be maintained. But you'll find that the most orderly place in any town you go into, the most orderly place is the graveyard. Not a single body moves. Nobody questions. Why am I in this grave? Why not in the other grave? How come the other grave is getting shade? I am not getting shade. Nobody moves, nobody questions. So society that does not question is a dead society. And when you question, the given order is disturbed. You find that there is disorder in nature. It's a natural state is constant change. The nature is constantly dynamic. The existing order is constantly challenged and constantly reshaped. This is natural. Stopping that process by insisting that the given order must be maintained is giving a death sentence to society. And so the only option for us is to make sure that that the questioning and the disorder and the reordering, I will not say disorder, questioning and reordering. There is no disorder in nature, but there is reordering. That process must not be violent. It must be peaceful. It must be non-violent. So we celebrate the fact that India, one of the only countries in the world, questioned the order of colonial rule and wanted to reorder India, as we said yesterday, constitute India into a republic, make India something it was not, a democratic republic, socialist, secular, democratic republic. By non-violent resistance against the given order, not by violent resistance. So we are committed to a dynamic society where the given order is constantly, like in nature, constantly challenged in a dynamic way, and that given order gives way to a new order and a better order, but in a non-violent way, in a passive way. So we celebrate the questioning of the old order and the reordering of society in a non-violent way, which is what gave us a new and independent republic. And therefore, these two ideas of right conduct, namely that a distributional idea of justice, and justice, right conduct as conduct that does not question, does not create any disorder, or and suppresses questioning to such questioning as will not question the current order, even for a good purpose or a bad purpose. This idea of justice is coming in the way of the constitutional idea of justice. The constitutional idea of justice is very different. It says, we want a society where right conduct means a conduct that supports and respects freedom and liberty of everyone to question the existing order or support the existing order, but to the liberty to do that. Right to equality, right to dignity, right to fraternity. So we have a country which has been opened up by the Constitution to encourage and allow people to question the new order, because we want to create a new order where there is no poverty and no suffering and no inequality. And everyone has liberty, equality, and freedom. This is our aspiration. So the Constitution has created a framework for questioning the existing order, because the existing order benefits a small number of people. According to a recent, very recent survey by Pew Research, a very respected data institution in the United States, 97% of the population of India live on less than 25,000 rupees a month for a family of 4. And that is, by global terms, low income or poor, 97%. Now, do we want to maintain an order in which only 3% are not low income or poor? The answer is no, we don't want to. But the Constitution gives us a framework for reordering ourselves into a better order where there will be well-being and welfare for everyone. And that is, so the Constitution has a dynamic process of change. The Supreme Court of India in 1980, SP Gupta versus Union of India, called the Constitution of India a charter for social revolution, a charter for social revolution. Right? But the tradition in the judiciary is to see justice as giving people what is due to them without any disorder or without questioning the order, which means giving what is due to them under the current order. And this view of justice of the Constitution, which speaks in its preamble of liberty, equality, dignity, fraternity, is colliding with the inherited traditional ideas of justice of the judicial system. And what we are trying to do I am trying to do, I'm an individual, I'm not speaking for anyone, is to try to align the concepts of justice which are applied in courts on a day-to-day basis with the constitutional idea of justice, and say that for us, justice means freedom, equality, dignity, fraternity. And unless these four values are upheld and promoted, to take the words of Article 39A, the operation of the legal system shall promote justice, then we will not achieve the constitutional aim of reordering our society, constituting India into a republic in which there is welfare and well-being for all the people of India, not just a 3% of the population. So this is the tension here, and so when I challenge the idea of justice and say it is not just about everyone getting their due share under the existing order. Yes, everyone must get their due share, but we need a due share based on the principles of equality, liberty, fraternity, and dignity, not on the current order. And yes, this change must, which the Supreme Court described as social revolution, must happen in a non-violent and peaceful manner through constitutional means and not through extra-constitutional, violent or extra-legal means. We are desperate. I am desperately struggling to make this happen so that we will not descend into violence. We are on the verge of violence. We should not forget that Baghdad is only as far away from New Delhi as Trivandrum is. That Kabul is only as far away from Delhi as Nagpur is. And so the region is on fire. Societies are descending into chaos and violence from which they cannot be retrieved. And when that kind of internal conflict takes place, outsiders come in and take over the place. That's what has happened in our history always. So we have to do whatever we can to establish, as Justice Rabindra Bhatt says, fraternity in our country. His judgment really gives primary importance to fraternity. Because when you have fraternity, that becomes a foundation of unity in the country and stability in the country. Genuine fraternity. So that's why I said that we want fraternity, and we realize that for fraternity, we need mutual respect based on equality. We need dignity. We need liberty. That is the kind of fraternity we need, not fraternity amongst unequals in a hierarchical society. We want fraternity amongst free equals based on their dignity and based on their self-respect. That is the formula of the Constitution. Therefore, unless every decision in every case asks the question, simple question, which is what Mr. Vishal Gogone asked in the case that we will look at first. How are we treating each other? How are we treating each other? And are we treating each other, respecting each other's, or on the basis of fraternity, friendship, mutual support, caring for each other? And compassion is a part of fraternity. It's not separate from fraternity. It is the basis of fraternity. So are we looking at each other based on the principle of fraternity, on the basis of equality and mutual respect, on the basis of liberty, and on the basis of democracy? And if we are not doing that, then the judge, as the auditor, the guardian, the protector of constitutional right conduct, must come in and correct that. And that's what Mr. Vishal Gogone did. It's one example. There are many such examples. I'm very fortunate that since I've worked with very large number of judges, they sometimes share with me the fantastic judgments that they write. And whatever I'm telling you now is really based on what I've learned from them. So what I propose to do today is we will first look at the judgment of Mr. Vishal Gogone granting bail in Delhi, very recent judgment, a few days ago. And we will try to understand whether his approach to justice is consistent with this approach that I've just described. Is he asking the question, how are we treating each other? And then is he finding the law? Justice Krishnaiyer once said that as far as a court is concerned, the challenge of justice is finding the law to uphold the values, not to be an arbitrary ruler imposing his personal sense of right or wrong, because that, we will come to that again, is fundamentally opposed to the idea of a democracy. It's a very dangerous idea. We did not throw the British out to have 20,000 judges ruling us. And so we don't want anyone ruling us. We want the laws that we create as a people, including all the judges, all of us as a people. We create the laws through a democratic legislative process, and those laws must be interpreted in a manner that advances the purpose of those laws, which is to establish a society based on fraternity. Given all the differences, all the conflicts we have, religious, caste, regional, resource-oriented, environmental conflicts, all kinds of conflicts, if we don't give primary importance to establishing fraternity and solidarity based on equality and liberty, then we will go the way of Iraq and Afghanistan before we realize it. And so it's a very serious battle that we are fighting, and the courts can and have, as we have seen in this case, ensured that mistreatment under constitutional standards, not under personal standards, mistreatment under constitutional standards and legal standards is corrected by a court. So with your permission, sir, will you display it or will I display it, sir? Shall I display it?
Yes, sir. Please display, sir.
Yes. With your permission, yes. This is an order. It's not really a judgment. It's a bail order, but it's a very, it's a very important bail order. Now, sir, can I request you, because you have read it and you have a lot. Can I request you to give some comments, sir, on this judgment from your point of view, in the absence of any other discussion? And I would be happy if there are any comments that are shared by any of. Yes, sir.
Thank you, sir.
For ability to talk. Yes, sir.
Thank you for giving me this opportunity. But I look it from more than one angle, sir. Some orders, even bail order or even a judgment will be like this. We will discuss what this side has argued, that side has argued, and we will quote some citations, etc. And we will proceed to pass with an observation. The following order will meet both the ends of justice. This will be one method without discussing what we understood from those arguments and from those authorities. And in another situation, this is one example of that another situation where the judge expressed his understanding of the values, the concepts, etc. And then he proceeded to pass this order, reasoning. So that difference I have distinguished it, sir.
Yes, sir. Anyone else has any comments, or do we have anyone else who's able to comment?
Sorry, it's not there in the.
Okay, in the platform, we are not able to do it.
Yes,
okay, sir.
Yes.
Fine, sir. We will work with this. Now.
So 13 onwards, sir.
Yes, sir. Yes, sir. But yes, sir. In 11, see the facts of the case. I assume that everyone has read it. It's a serious case. The allegations emanate from the FIR. Complainant alleged that his daughter, who had been married to accused Tinku, was subjected to repeated demands for a motorcycle, so dowry. His younger brother, namely Sunil, his elder brother, namely Deepu, that is, and Suman, it is elder sister-in-law, Suman, who is the present application, and father-in-law, Dilip Chowdhury. They were all making demands on her. she could not provide the girl's family could not, the wife's the complainant could not, the father could not provide the motorcycle for want of resources, which led to the accused persons repeatedly beating up his daughter. She was not provided proper food and forced to consume non-vegetarian food. It was further alleged that she was kept hungry for 4 to 5 days. These are the realities in our country. Should we not challenge such a social order? Should we not reorder it so that, I'm the father of 2 daughters. I have no sons. I'm a son myself, but I have no sons. I can imagine the pain of this father to see the daughter in this condition. The specific allegation against the present applicant is Suman Kumari was that she had intended to get her sister married to Tinku, so forcibly made the deceased consume a medicine to cause abortion of a 3-month-old fetus. It was alleged. These are not established facts. The deceased was found hanging, that's a fact, with a ceiling fan using a gamcha, a cloth, and so discovered by her husband on 1/12/2020. So this is very recent. It's December 1 last year, in the middle of COVID. The learned counsel for the accused. So what the accusations are very serious, no doubt, and heartrending. So our counsel for the accused made the usual arguments, which we need not get into, and then we come to para 11. While agreeing that the child of the applicant or accused is quite young in age, the learned APP. So I should APP submitted that he had not been separated from his mother and was in a safe environment in a company. The court has considered the charge sheet and the submissions made by the respective counsel. Now we come, para 13. Apparently, the allegations relate to demand and harassment with a view to obtaining dowry and beatings inflicted in this context. They also relate to forcible administration of a pill to cause abortion of the fetus of the deceased. The pleas raised by the learned counsel for the accused with respect to the merits of a charge under section 304B would be considered by the court at the stage of framing of the charge. Whether for purpose of framing charge, the allegations constitute harassment for dowry soon before her death is a question or stage yet to be reached at the trial. Specific allegations have been forwarded in the charge sheet. The gravity of the same cannot be discounted and thus operates as a dissuading consideration in the matter of bail being granted to the present applicant or accused. Now we know that this application, as all of you know, but for just for the so that we are all on the same page, this decision or the application for bail is being made under section 439 of the Criminal Procedure Code, which says a high court or a court of session may direct that any person accused of an offence and in custody be released on bail. Right, and then there is if there's previous conviction under 437(3), not relevant here, which it considers necessary for the purposes mentioned. That's not so. Any person accused of an offence and in custody be released on, may direct that any person accused on offence and in custody be released on bail, that any condition imposed by a magistrate when releasing any person on bail may be set aside or modified. So very broad power given to the sessions judge and the High Court, which simply says any person accused of an offence and in custody be released on bail. So if we read this only as a legal provision, then we say, to what end, for what purpose should this power be used? Every power is given for a purpose, and that is central to the idea of rule of law. Limited power, the power is only for a purpose. In a feudal society with a Maharaja, you have power given for any purpose that the individual, power is given to the individual. Here the power is given to an official, not to the individual. The judge is a function, not a person. It's a function and not a person. And so if you look at section 19 of the IPC, section 19 of one second. Section 19 of the IPC, which defines judge. Now, first, court of justice. Words court of justice denote a judge who is empowered by law to act judicially when such judge or body is acting judicially. So we know that this court has to act judicially. Judicially comes from the word jus, J-U-S. That is the root of the word judicially. So ultimately, to act judicially means to uphold the right value, the right use. And then the word judge is defined in section 19, and in the illustrations in section 19, it says a magistrate exercising jurisdiction in respect of a charge on which he has power only to commit for trial to another court is not a judge, is not a judge. So please understand that a judge is not a human being. When a magistrate sits in the court and commits somebody to another court for trial, he is not a judge according to the law. He's acting in an administrative capacity or some other capacity, but the law says he's not a judge. Therefore, we must understand that the law, the concept of this is the rule of law. That if we believe that a judge is a judge when he's brushing his teeth, he's sleeping, he's getting up in the morning, he's having a shower, when he's talking to his, his staff, he's a judge. But actually, we are like a professor is a professor only when he is in class teaching. We think a professor is a professor when he sleeps, gets up in the morning, brushes his teeth, talks to his staff. That's just a colloquial usage. But a professor is a professor only when he's teaching in a class that is authorized and expressing a view that he's supposed to independently express, like a judge, for the purpose of advancing education. So therefore, when we come to section 439, although, and I'm responding to many of the questions that were asked, that's why I'm going into in some detail. When we're looking at section 439, it seems to be written in extremely broad terms, like Article 142, complete justice. By the way, the word complete justice is only for the Supreme Court. Section 151 of the Civil Procedure Code simply says for the ends of justice. So I don't know why we are now suddenly talking of everybody doing complete justice. The law has not given that mandate to anyone except to the Supreme Court. But even that is given not to the judges who happen to be sitting on that chair, but it is given to the function of a judge. And it is therefore to be, we have to ask the question, how do you interpret such a power? And my submission is, you have to read every such provision in conjunction, must be read with Article 39A of the Constitution. And what does Article 39A of the Constitution says? I can tell you by heart. It says the state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity. We read it as a legal aid clause, but legal aid is only an instrument to achieve the real substance of that clause of the Constitution, which basically says that the operation of the legal system shall always promote justice. So therefore, in deciding whether to give bail under 439, the judge, not the individual, the judge, the function of the judge is to ask what is the purpose of this function for which this power has been given, and that is to promote justice. So let us deal with that question of what is discretion. Discretion that is to be is a function of the judge, where when, as in 439, when there is no clarity about what is the basis on which bail should be given, that function requires us to separate the grounds of that decision which are authorized by law from those that are not authorized by law and are purely subjective. Because you have had a sense of, a number of questions say that, look, we know what is going on. When the judge has knowledge which is not on the record, the individual may have knowledge which is not on the record, but please remember the judge never has knowledge which is not on the record, because the judge is a function. So therefore, the challenge of discretion is to separate what is subjective, what is personal, what is not on the record, and look at the Constitution, look at analogous provisions of the law, and derive from there, through the doctrines of interpretation, authorized doctrines of interpretation, the principles and grounds that can be relied upon to exercise this function to advance justice, because that is the role. And justice, as I said, there are two broad views. One is the view that justice means, actually the original traditional idea of justice in the Raja era was Dushta Danda, Sajana Puja, Kosha Vriddhi, Rajya Raksha. Dushta Danda, Sajana Puja, Kosha Vriddhi, Rajya Raksha. So yes, you give bail subject to these four concerns. Dushta Danda, so there is a Dushta has to be given Danda. We assume we through judicial instinct, the judges know who's really guilty and who's not, and that's why they say, I have personal knowledge. That's not consistent with rule of law. The rule of law, there is no individual judge, there is only a function, which is why 19 says, the illustration in 19, section 19, it says that a magistrate who's only committing for trial is not a judge, because that's not a function that is judicial in nature. You're just transmitting. It's like you're just transmitting the case from one court to another court. There is no application. There is no responsibility to uphold use, which is the root of both judicial and judge, which is the function of the judge. And therefore, we have to understand this is where the application of the idea of justice is very important, and where this judgment immediately asks that question. Does not say, look, I have unlimited discretion. So discretion is actually not meant to give you personal power. On the other hand, discretion is meant to ensure that you do not exercise personal power, that you separate the grounds that you will take outside the statute, which are legal, from those which are not legal. Okay, so now let's see how this judge, Mr. Vishal Gogane, approaches it. He says, he first starts off with a very high level statement. What is a court? So he just doesn't look at 439. He says, okay, I'm in a court. What is a court? And we've said a court we've defined court as an activity where a judge is acting judicially. And for that, you require all the parties and a procedure to be followed. So he says, a court of law is a forum where the right to liberty has to often yield to the rule of law. And persons accused of the commission of offences may find their applications for grant of bail declined for various reasons. So he's looking at the function, that there is a right to liberty and the rule of law. Denial of bail to such persons, especially women, does, however, often operate as a de facto detention of their infant, toddler, or wards. Being neither the subject of trial nor required to be in detention for any reason, such children still languish in jail for terms coterminous with the period of detention of their mother. So he says, look, I have to protect the right of liberty. And yet, when the law authorizes detention, liberty has to be deprived in the interest of the liberty of others. But he says there is one factor which we are not taking note of, he says, not in so many words. He says, especially women, when we put them in jail, we are also putting their children in jail. And there is no legal basis for that. So now he looks at the law. India is a signatory to the United Nations. Look at the level in which he's identifying what is justice. What he's doing is he's understanding the Constitution and understanding justice in this bail order. If you tell me you have no time to do this, if Mr. Vishal Gogone has time to do it, then I think we all have time to do it. He's a very busy judge. I've had the privilege of interacting with him when he was at the Judicial Academy. And frankly, time comes because very often things take a lot of time because of lack of knowledge. If there is knowledge and competence, things can move very quickly. So the lack of time is not always, but very often overcome by ensuring that we are intellectually well prepared. So Mr. Gogone is intellectually highly prepared. He reads a lot, he thinks a lot. There's a deep reflection on what courts do and what justice is, as Mr. Yaralagadda does. I'm sure he disposes of matters like Mr. Gogone very quickly. Now he says, so he immediately is already within his knowledge. No, no one has to tell him that India is a signatory to the United Nations Convention on the Rights of the Child. And so he's now entering into the core question of justice, which is how is the state treating this child? Is the state treating this child in a fraternal manner or in an inimical manner? So he says the convention mandates that detention of children should be only a matter of last resort and for the shortest period of time. And even if it is required, it says that children should be separated from adults. The primary consideration of the best interests of the child in all actions concerning children taken by courts of law, enunciated in Article 3 of the Convention, finds recognition in the Juvenile Justice Act of 2015, which actually in the year 2000, the original version, arose from the United Nations Conventions on the Right of the Child. Through Section 3, which requires that all decisions regarding the child shall be based on the primary consideration that they are in the best interest of the child and to help the child to develop full potential. Section 3 also advocates, so look at how he is not acting arbitrarily. He's saying there is a law that to implement the constitutional vision of liberty and fraternity. There is a law that provides a standard of conduct, a standard based on which we should treat a child. Section 3 also advocates institutionalization of the child as a step of last resort. The same provision mandates that a child in the juvenile justice system should be restored to the same socio-economic status and cultural status that he was in before coming under the purview of this act. The child of the applicant is 21 months old. He has not yet seen 2 years in this world. Not being a child in conflict with law or a child in need of care and protection within the meaning of the JJ Act, not within my personal view, but within the meaning of the JJ Act, it may be a view too myopic and pedantic to take that the child is not in the juvenile justice system and therefore the law does not apply to the child. So he understands that the principle, this is like I said yesterday, if I tell someone do not use the word tu, but that person uses an equivalent in another language, it would be too myopic and pedantic to say that you should understand my purpose. My purpose is we must treat people with respect and dignity. I was not focusing only on tu. So we must understand the higher purpose for which law is made. A very experienced judge once told me, he said, Professor, every law is made by the legislature to advance a good purpose. That purpose is not written in the legislation. It is often not even written in the preamble or the objects clause. But the challenge of the judge is to identify that good purpose and ensure that and to safeguard it and take it forward. That's what Mr. Gogone is doing here. He's saying that the purpose of the Juvenile Justice Act is to establish a certain principle of conduct, a value of conduct on how we treat children. And so it would be too myopic and pedantic to say that you first have to be a child in conflict with the law or child in need of care and protection of the law to be treated properly as all children should be. So the court would pose to itself whether for reason alone of not conforming to the above description as CCL or CNCP, the child can be denied the protection of the principles governing the child rights regime. The answer is an unequivocal negation of such a proposition. Being only the son of an accused and yet suffering de facto detention, the child must not suffer rigorous, any more stringent than a child who would qualify as a CCL or CNCP. Yet the child filed himself incarcerated for the alleged actions of his mother. It bears empathetic but emphatic mention that the continued detention of a child of a tender age, even if in the custody of the mother, would have a foreseeable adverse influence on his socialization, sensory enrichment, and overall physical and mental development. This is the heart. This is not Mr. Gogone speaking. This is the Constitution speaking. This is the Constitution speaking. This is where fraternity is based on compassion. This is an illustration of compassion, where he's drawing compassion from the Juvenile Justice Act. And he says, look, when you say the best interest of a child of 21 months of age, we have to be conscious about how that human being, that little bud, is flowering in a jail. The options for preschool and other educational enhancement would necessarily be restricted inside the central jail. Since the trial has not even commenced and is likely to take a length of time to complete, the son of the accused, barely two years in age, it could be the title of a good movie, The Son of the Accused, barely 2 years in age, cannot be condemned to spending, because there are so many of them in this very tragic condition of being punished for no fault of their own, cannot be condemned to spending his early childhood in jail. Such a fate would be a violation of his right to healthy development as an individual. All of these are constitutional values of his liberty, which includes his Article 21 right to life and liberty, personal development. Thus, in recognition of the rights of the child, and observing that a system which is predicated on the presumption of innocence and of the accused should not subject the child of such an accused to detention without cause, the court finds it fit that the applicant is granted liberty to face trial as a free person. Bail to the applicant is in fact a release of a little child to freedom. Now, this is an example of the application of everything we discussed yesterday, where we are saying, look, what a court does is to protect the values that should inform how we treat each other as human beings. Take all the institutions, organizations, laws, and all that aside. Ultimately, we are human beings treating each other. The rule of law says you are not an individual treating someone else. On behalf of the people, you are a function. And that function must treat each other in the manner prescribed by the Constitution and prescribed by the law, according to the principles that are in those documents, instruments. And that is what this judge is doing. There is nothing arbitrary, nothing personal, strongly reasoned, based on law, advancing the constitutional values, and seeing justice as a protection, as a standard of human conduct, according to the Constitution, seeing justice as right conduct, and saying that the conduct towards the child is not right, and therefore justice means upholding the right conduct. So let me stop here on this discussion and see if you had anything to say. So my emphasis here is not on the final decision. My emphasis is on the reasoning, how he understands the four, actually five is the fifth plus one, the four forces that uphold the judicial system, the physics of justice, the four forces that uphold the judicial system, namely the Constitution and its values. The Constitution's Grundnorm, not just the administrative governance part of the Constitution, but the Grundnorm of the Constitution. Then the idea of justice, not just as Dushta Dand, Sajana Puja, Kosha Vriddhi, Rajya Raksha, but as upholding justice as freedom, justice as liberty, justice as equality, justice as dignity, and the rule of law, that there shall be no arbitrary personal, subjective decision making. A judge is not sitting there like some Maharaja to dispense justice as he sees right, but justice as a function carried out to advance the constitutional vision of justice in accordance with law. And reasoning. How he has taken the facts, as I said to you yesterday, and we'll go into it in more detail, reasoning, and we'll find the definition of reasoning a little later in the Evidence Act. In the Evidence Act. It is about how facts are connected to each other. So Mr. Gogone takes various facts. This woman is accused of a serious crime. This woman is in jail. This child is in jail. This child is 21 months old. The atmosphere in the jail, the rights of the child, the principles that should govern how a child should be treated internationally and in international law as well as in national law. And he connects all this together. And when he connects all together, a result necessarily follows. Necessarily follows. And when these four forces of the judicial system that uphold the judicial system come together, the decision becomes very strong. Now, these forces are not obvious to you. Like every morning, a pilot is not given a report on how much gravity there is. Today, gravity is more, gravity is less. Gravity is always there. Gravity is uncompromising. The pilot can have whatever discretion he wants, but if he violates gravity, he will crash. There's no compromise on that. You cannot violate gravity. You cannot violate drag. You cannot violate the air and the movements of the air. You cannot violate the physics of lift, that if you burn so much fuel and push so much air, you will get thrust. These laws cannot be violated, but they're not told to him every day. But when he's sitting in that pilot seat, these are the four laws that are governing the pilot. Similarly, Mr. Gogone is sitting in his chair, and the unseen, invisible, non-negotiable forces that have put him in that chair and will protect him in that chair are Constitution, the idea of justice, the rule of law, and his reasoning. And if he fails in reasoning, he will crash. If he violates the rule of law, he will crash. If he does not understand justice properly, he will crash. And if he does not understand the Constitution properly, he will crash. But if he takes the effort to understand all this through reading and learning, then the jury function of simply deciding whether this woman gets bail or not, is punished or not, is easy for anyone to do. In the most educated countries in the world or least educated countries in the world, ordinary people with no expertise are making these decisions as jurors. But understanding these four forces and ensuring that those four forces are respected and not violated, that is a very technical, very involves and requires a lot of learning and a lot of knowledge. And our judges, especially the younger judges, are easily going just to the jury function. And I'm always saying, actually, in many of our courts, we have the jury system, except we have a one-person jury who is simply jumping to the jury function. And these other four forces are getting neglected, which is really what holds the judicial system afloat. And in this judgment of Mr. Vishal Gogone, you see how these four forces are operating to produce his judgment. And that's why I thought I will share this with you. This is a very recent judgment, 31st of March. Let me stop here, sir, and see if you have any comments or any comments have come through.
Sir, you have covered those queries just now. I was about to say how again completed.
Yes, sir.
Yes.
Yes, sir. Okay. I wish we had a process of physical interaction. I mean,
sir, I even got a message from the participant that I think the esteemed speaker has substantially answered my query.
Okay, sir.
So that's what they are getting the answers also through this section. Please continue.
Sir, should we take a break now, sir, or take a break at a little bit later? Because now I would like to discuss the George Floyd instructions to jury.
I would suggest we continue and later on take a break, sir.
Yes, sir. We can take a break like yesterday around 11:30, 11:45.
Yes, sir.
Yes. Okay, sir. Okay, so I'll just not jump into the other thing. I'll just give everyone a minute or two to think, because I'm sure many people don't agree with me, and which is good because I'm the one who's preaching that there should be disagreement, there should be questioning. Every given order, if our country is to have a good future, we must always question the existing order and want to create a better order. Our mantra should not be maintain order. Our mantra should be build a better order, no matter how good the order is. No matter how good the order is, build a better order. Let's have something even better than what we have. That's what we owe our children and our grandchildren. And you're all very young, too young to talk of grandchildren, but that's what we owe the future. So we see Mr. Gogone not seeing Section 439 as a blanket personal discretion to grant bail or not grant bail, which is how you can read 439. But you see him understanding his role, his function, and these four forces, and applying these four forces, and then it reaches a result. Frankly, whether he gives bail or not gives bail is a juror's decision. I'm not interested in that. I am interested in the reasoning, the process by which he has reached that function. Yes, sir. Yes, sir.
So as you said, sir, that there should be some disagreement with your view. Again, it is there. So I may be allowed to speak.
Yes, please, sir. Please, sir.
Sir, while I appreciate the learned judge's sensitivity and compassion towards the child of the accused.
You're reading a comment, sir? You're reading a comment?
Yes, sir. While I appreciate the learned judge's sensitivity and compassion towards the child of the accused.
Yes.
What about the examination of the question of bail vis-a-vis the nature and gravity of the crime, its impact on the society, etc.? He adds, sir, not a single parameter was laid down by the Honorable Apex Court in the case of Prahlad Singh Bhati case or P. Chidambaram's case for grant or refusal of bail has been discussed or examined in the order. Has this order done justice to the victim and the society?
Sir, again, thank you very much to the Honorable Judge for raising this question. And it shows, I think, again, it goes back to the point of if I could have the pleasure of discussing with him, the first question I would have asked him is, what legal principle or constitutional principle is he basing his argument on? Where is the constitutional principle that a person who is entitled to, as Mr. Gogone says, is entitled to the presumption of innocence? This person is an under trial accused, not convicted. But the questioner is assuming already that releasing a person who is accused by the police, sir, my father was a police officer, Indian Police Service, so I mean no disrespect to the police. He was an army officer, later became a police service, so I don't disrespect to the police. But he was one who all his life fought against corruption in the police, sir, and suffered for it. He became a very senior officer, but he suffered for it. There is massive corruption in the police. We know that. Why are we taking at face value, sir, what a system which we know is very, very corrupt is putting before us and assuming that a person is guilty? I'm not saying the person is innocent, but that will emerge from a process. Now, if you read the structure of the Indian Penal Code and the Criminal Procedure Code and the Constitution together, the reason why 439 is so sweeping is you will find that in the Criminal Procedure Code, there is a provision on arrest, which limits the power to arrest. There is a provision on bail, which gives very broad power to give bail. There is no provision to imprison an under trial person except under Section 4, the parameters laid down for a person who are arrested under non-bailable offences in section 41 of the CRPC, which means that the presumption of the law is that in the normal course, except in exceptional circumstances, a under trial is not put in jail. But the fact today is 70%, 70% of the prisoners in our Indian prisons are under trial prisoners kept there by judges. 70%. But the presumption of the law and the constitution is, there is the provision in the Criminal Procedure Code that once you're convicted, you will sent to jail. You will be convicted, and in the Indian Penal Code, you will be imprisoned, sent to jail. But there is no provision for keeping in jail an under trial prisoner as a process of punishment or in any other capacity. This is, you can arrest on these limited grounds, and then you've got a broad power to give bail. This is why Justice Krishna has said, bail not jail. Not because he was expressing his philosophy. This is the philosophy of our law. Why? Because the ultimate, as just Mr. Gogone, Judge Gogone has said, he talked about liberty. But he's saying, yes, now where are these other considerations saying that because you are accused by the police of a serious crime, Section 41 says, if the crime is serious, the gravity of the crime is one of the reasons why you may be kept under arrest. But the real purpose you're kept under arrest is because it's a serious crime and you may flee the jurisdiction, and the serious crime may go unpunished because somebody has fled the jurisdiction, or you have tampered with evidence, or interfered with the process of justice. Or you're a threat to others. You've committed a serious crime, and if you're not detained, you may commit further crime. But the point that the honourable comment, the speaker who has given the comment has made, which I would with great respect, want to understand further is, how can we say that because a person is accused of a serious crime, that person must be kept in jail? Sir, people are sent to custody for custodial interrogation. Article 20 has a right against self-incrimination. In fact, the question examined by the Supreme Court has been, can you interrogate while in custody? And the Supreme Court has said, yes, you can interrogate while in custody. But we have gone further from that and said, look, can you be sent into custody for interrogation so that you can be intimidated? You can be put under harsh conditions and then forced to construct a case against yourself. So the police in our country expects every accused to construct the case against the accused. The law gives us the right to silence. Now, the question of the victim has to be separated from the question of the right of a fair trial to accused, which God forbid that no one in this audience will face that situation. But you and I know, sir, including in Bombay, cases where judges have been accused of crimes. Rare cases where a judge has been accused of a serious crime, including under Makoka. And when that happens and the judge languished in jail, when actually he was acquitted, eventually he was acquitted when the trial was carried out, he was acquitted. But he languished in jail, he was dismissed from service. And by the time he was acquitted, his health and his mind had collapsed to such an extent that he died before he could be restored to office. So these are principles that will protect all of us, sir. I don't know whether that judge, when he was a judge, I don't know at all. Maybe he did, maybe he did not. Whether he was conscious of the importance of the right against self-incrimination, the right the presumption of innocence, the right to silence. These are all fundamental principles, sir, of the idea of justice, natural justice. The two principles of natural justice, the audi alterum partem and nemo judex, that you have the right to be heard, and no one can be a judge in his own cause. These are all part of the idea of justice and sub-part of the idea of liberty. These are all very important this is the only reason we have a judge. If you wanted to punish whoever the police finds as an accused and put that person in jail and give solace to the victim, sir, I feel then we don't need a judicial or legal system, sir. We don't need law teachers like myself. We don't need law students. We don't need lawyers. We don't need judges. The police can do all this. Why should we come in the way? We are there only to protect these principles and protect liberty. And as far as the victim is concerned, every help must be given to the victim as in other countries, regardless of whether a person is accused or not, convicted or not. That is the right of the victim and our responsibility to the victim. Financial help, psychological help, physical help, material help, all should be given, because when a person is subjected to a crime, that victim, it is society that fails that victim. And most countries in the world have separated the question of crime and punishment of the accused. A victim of the crime and punishment of the accused, which is the right thing to do, because especially given the deep failures, How many senior judges, sir, I can't count, have said that the criminal justice system in our country has collapsed. And yet we are saying that someone accused by the criminal justice system, not convicted of any crime, should be kept in jail to give solace to a victim. We are saying that, sir. I can understand, layperson saying that. Yes, sir.
Sir, there are such similar expressions. What is the, are we not concerned with the victim also? That is what they have expressed. You have covered,
Yes,
sir. Thank you.
Yes, sir. I've answered that, sir. Sir, let me now then move, for lack of time.
Yes, please,
the next part is, before I get into George Floyd, I want to connect these two, sir, by answering a number of questions that were asked yesterday on reasoning, and what is reasoning and what is the role of rule of law and reasoning. The rule of law is basically to prevent any personal subjective exercise of power, and that all power shall be only exercised within the limits of the grant of power and for the purposes of grant of power. Sir, what an official is really an agent of the state, sir, an agent of the state. When you are sitting in an office, in a public office, you're acting as an agent of the state. You're acting for the state. And so the broad principles that apply to agency, that you can only act within the power given to you and for the purposes for which the power is given to you, will apply to every official. And that is at the heart of the idea of rule of law. We don't want to be ruled by individuals. We don't want to be ruled by subjective decisions, either positive or negative. Now, let me, the implementation of the rule of law takes place through the process of reasoning. And one or two questions yesterday asked me about legal reasoning. So I find, sir, for judges, I don't want to give a theoretical. We can go to the internet and find a lot of theoretical discussion on reasoning, inductive reasoning, and deductive reasoning, and all those things. But I would like to tackle the question of what is judicial reasoning of a court, very narrow type of reasoning. Because reasoning occurs, we are always reasoning. As human beings, we are reasoning. As I said, reasoning is simply a process of structured thought. I was telling Mr. Yaralagada yesterday that if I want to pray to God to end COVID, I can do it in a very unstructured way. If I'm very informal, and many of us have very informal relationships with God, we can say, "Yaar God, yaar, kya kar rahe ho, yaar, kuch karo, isko band karo, jaldi band karo, God." And we'll say, "Tu ye jaldi band karo." That loving relationship, informal relationship with God. But if we are structured, then we will say, "Mukam karoti vachalam pangum lankete girim yat kripatam vandeta paramananda madhavam," blah, 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 right? We will provide a structured prayer to God. Now, there's simple reasoning, unstructured thinking, and there is structured thinking. Now, the rule of law requires that all judicial reasoning has to be structured. And the structured reasoning, similarly, sir, take Christian prayers, Muslim prayers, Buddhist prayers, Buddham Sharanam Gacchami. So those three words, sir, structured words, profound words. or the prayers that the Muslims say, the prayers that the Christians say, structured prayers, very powerful structured prayers that will regulate our thought and our mind. When we say, when the Muslims say in prayer, they're just telling each other, Allah means God, doesn't mean Muslim God. It's like Bhagwan in Arabic, God. They're saying praise be to God, the only God. There is only one God. So immediately your mind has been structured that there cannot be more than one God, that He is the only God and He is great. So structured thinking is very, very important. And the biggest challenge I find, sir, after 17 years of close interaction with the judicial system is much as a practical matter, not when you read the judgments. The judgments are made in the head, sir. Decisions are made in the head, not on paper, by us, by and large, not on paper. And they're made in an unstructured way. But I find, sir, when we understand the process of structuring and we write down that process, the structure starts to get strong. So if I have to write down what I'm saying now, it will be much more structured than what I'm speaking now. So even writing, and someone asked me, what is the difference between judgment and justice? Judgment is basically a written record, a written statement of the reasons for the decision made by the judge, which must promote justice. So why do we reduce this to writing? And why do judges say, why do we need to write a judgment? Because it forces you to structure your thoughts. And they're resisting that structuring, sir, when they're saying we don't want to write. Now, academics like me, we can only write, sir, because we don't like the unstructured thinking. So somebody asks me something, I'll say, give me a day or two, I will send you something in writing. Opposite of judges who are saying, many judges, not all judges, who are saying, sir, why do we need to write judgments? Because it is the only way that you can ensure that your thinking is actually structured. So the first point I'd like to make, sir, is that the process of rule of law and to advance justice must be based on structured thinking. Now, what is the structure of that thinking? The core structure. The core structure which is applicable to judicial thinking, sir. Sir, it consists of the following elements, sir. The first element of that core structure is it must be based on facts. The second element of that structure of judicial thinking is there must be a connection between facts. A pattern of connection between facts. And the third element is, sir, that connection must necessarily, that connection between facts, when I say facts, I mean proved facts here. That connection between facts must necessarily lead to the existence, non-existence, nature or extent of right, liability or disability. And there is no discretion, sir. You have facts. You see connections between facts. When facts are connected, they become relevant facts or facts in issue. And when from those facts and their relationship with each other, the existence, sorry, I will not get into that. From those facts or their relationship with these facts, right, liability or disability necessarily follows. Then you've got judicial reasoning. I would say these are the three fundamentals of judicial reasoning. So in every case, ultimately, sir, if you take the Evidence Act, it says there is an assertion or denial in any suit or proceeding, civil or criminal. There is an assertion or denial of the existence, non-existence, nature or extent of right, liability or disability. That's the only reason why somebody comes to a court. It is in respect of wrong human conduct. Yesterday there was a temple festival in Thrissur, very famous temple festival. A very big tree's branch broke, from very high tree, and 2 or 3 people died. Unless we can prove there is some human negligence, no one can go to a court against a tree. One of the comments said, sir, why animals are fighting and killing each other, we are not bringing action against them. I said, yes, because we are only concerned with human action. If somebody releases those animals to some, and then the animal does something, or the animal belongs to somebody and you have damaged somebody's property, yes, there can be a cause of action. So, sir, every suit or every proceeding in every court of law, Supreme Court to Junior Division Court, involves the assertion or denial, must involve the assertion or denial of the existence, non-existence, nature or extent of right, liability or disability. And that question must come from relevant fact or fact in issue. Why? Because no evidence can be introduced in any court of law in India except on relevant fact and fact in issue. And so you must have facts, and the law is what creates the right, liability or disability. In order to protect and promote justice. Justice is a pure norm, a pure set of values, no practical application. The law, like 439, is a pure hypothetical fact pattern. Somebody is in jail, this court has given the power to give bail. It doesn't tell you anything normative. But what are the values to be protected? What are the values governing human conduct that should be protected? That is why they work beautifully together, sir. The idea of justice is purely normative. Purely normative. And the laws are purely hypothetical facts, which don't tell us explicitly what the norms are. But they have to work together. The hypothetical fact pattern has to be applied and wrong conduct has to be protected as prohibited, proscribed, as Mr. Gogone said. Keeping a 21-month-old child in jail cannot be allowed in order to uphold and take forward the normative ideas which are only in justice. And he finds them in justice and implicitly in the law. The Convention on the Rights of the Child, the Juvenile Justice Act, the standard that the best interests of the child must be protected. These normative statements are embedded in the law, authorized by the idea of justice in the Constitution. So this is how they work together, sir. Now, let me just read the definition, sir, of the 3 most important components of judicial reasoning. Very important for us to remember. I always believe, sir, that if I wake up a judge in the middle of the night at 2 o'clock while he's deeply asleep and ask him what is the definition of relevant fact, he should be able to recite it without waking up. Because it is probably the most important definition for a judge. And if he bears this in mind, then there will be a lot of clarity about what this job involves. Not a panchayat job, not a juror's job, but it's a very, very highly important and highly sophisticated job. Sir, you know that a fact is defined as very beautifully as basically a thing or a mental condition. A thing which is capable of being perceived by the senses. Or a mental condition. So this is a very powerful definition, sir. It says that I cannot say a ghost is a fact because it is not a thing that is perceivable by my senses. But suppose I do perceive a ghost, others cannot. Then it becomes part of my mental condition, of which I'm conscious. Then it can be brought in as saying, look, Mohan Gopal has seen a ghost. Because that's his mental condition. But you cannot say that a ghost is a thing, which anybody can see with their material senses. very simple, very beautiful architecture, sir, of fact. And we know what that we know, sir, that approved. We know approved fact is a fact which, when after considering the materials before it, not on the basis of some comment said, when the judge knows that the person is innocent or guilty. A judge cannot have such a view, sir, because a fact is said to be proved when after the matters before it, not before the judge, before the court, because both sides have to see it. So after considering the matters before the court believes, not the judge believes. The court is an activity. So the court as an activity comes to the belief that this fact, this thing, or this mental state, mental condition exists. Believes that it exists, or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. So we have proved facts. So the first element of structural of the structure of reasoning, of judicial reasoning, is you must have proved facts. So Mr. Gogone takes the proved facts that this child is 21 years of age. The child is not a child in conflict with the law or in need of care and protection of the law. Facts. The second, sir, is a connection between the facts. The connection established by law. So the child is in jail. The connection that child is in jail is because the mother has been accused of a crime. Is there a connection between the child and the crime? No, there isn't. You can't draw a line from the child to the crime. You can draw a line from the child to the mother, but the child is in jail. So you connect the facts together, and then you connect the child to the rights of the child. And then you say, look, the child has a right, that right has to be protected. And is there any law that says this woman cannot be released by bail? No, he has the power to release her under bail. The assumption is that, look, an under trial should not be in jail. And there is no compelling reason that is argued that the under trial should be in jail, that she's a threat to the child. So if she actually harmed this victim, then she may harm the child. So evidence should be brought, look, she cannot be released, in which case the child cannot be with her in jail either. So the prosecution can produce evidence saying this woman has to be kept in jail because she's a threat to herself, she's a threat to others, she's a threat to the child. No such evidence was faced. No facts have been put before the court on that. And therefore, when you take these facts and the connection of these facts and the principles of law, and then the third question is there a liability for this child to be in jail? The answer is no. There is no. The facts in issue, the facts and the facts in issue, is there a liability for the child to be in jail? Is there any fact in issue that leads to the conclusion that the child must be in jail? No, there isn't. Other than that the mother is in jail. And is it in the best interest of the child alone to be released and separated from the mother? No. Is there any liability for the woman to be in jail, separate from the child? Prosecution has argued that has not produced any facts saying that there's any reason for her to be in jail. And therefore, the conclusion that mother and child must get bail necessarily follows. That word necessarily follows, fact in issue, means and includes any fact from which, either by itself or in connection with other facts, the existence, non-existence, nature or extent of right, liability or disability, asserted or denied in any suit or proceeding, necessarily follows. So you'll find, sir, in this structure of Mr. Gogone's discussions, you can see that this decision necessarily follows from structured reasoning. And there is really no other conclusion that can emerge from the structure of judicial reasoning. However, there may be judges in courts below him or courts above him who may take a different view, who may not then we may not be able to find whether that structure of that reasoning is not obvious, unlike in his order. But in my view, that would be legally wrong, and that would be a violation of the principles of rule of law. So I'm trying to use this case to show how in a bail order, the ideas of rule of law and reasoning, which are one of the four forces that keep the judicial system in the air, operating successfully, have been followed and applied. Now I would like to demonstrate this in the George Floyd case. That'll take about 10 minutes or so. Should I do that now, or should I take a break? It's been a bit heavy, sir. What I'm saying is somewhat heavy. Should we take a break now, sir, and then come back in 10 minutes and then move to George Floyd, sir? I think we should do that, sir. Perhaps 10 or 15. I can't hear you, sir. I think you're muted. Sir.
Sir, you can take a break, and if you have time, sir, cursorily go through those charts also. Meanwhile,
yes.
So that part will be completed.
Yes, sir. Yes, sir. We'll come to the chats at the end, sir, because while I finish this, some of those will be covered. Then we'll go through the questions, and then we'll see what has been covered, what has not been covered.
Sir, we will come back at 11:40. Now
it
is 11:28.
Yes, sir. Yes, sir. Yes, sir.
Thank you, Chetan, sir.
After doing that, I will also deal with this question of QRTE.
Yes.
I'm dealing already with Q and R, because this is what Q and R is: quality and responsiveness. And responsiveness, there is some access to justice issue I will address. Then we will move to timeliness and efficiency very quickly. And then we will come to the questions and end.
Sir, yes.
Yes, sir.
So participants, kindly take a break of 10 minutes and join at 11:40. Okay, sir.
Okay,
Chetan,
sir. So 10 minutes from now.
Yes, sir. सर कुछ प्रॉब्लम्स आपने शेयर किया ऑलरेडी लिंक? कुछ लोगों के मैसेजेस आ रहे थे.
I have also shared the link in the chat itself. I've made an announcement, so anyone and everyone can see the webinar link.
Yes.
It's in the announcement now.
And please put that announcement also, sir. Yesterday's recorded session also can be accessed through the yesterday's link itself again, once again.
I'll do that. I'll do that, sir.
Okay, sir. Thank you.
That link and mention it over there itself.
So I will come back in 10 minutes.
So 10 minutes. Yes, sir.
Sir, I am back. Once again, welcome you, sir.
Thank you, sir.
I request you to resume the session, sir.
Yes, sir. Thank you very much, sir. So what we will now do is to search and identify these four forces: constitutional principles, ideas of justice, rule of law, and reason, that are how they are actually applied and used in specific cases. We've dealt with that in the bail order of Mr. Gogane. And I'd like now to, and I understand some of you at my request have identified and shared the instructions to jury, but we'll put it on the screen. And I'd like to now go through the instructions to the jury with the view of identifying whether we can see implicit in these instructions these four forces at play. It's like flying in the plane and looking for how the plane is reacting to gravity by using air and using thrust, fighting drag and fighting weight. So when you're riding in a plane, you can actually see how the flaps move up and down. The plane puts itself at an angle to move away from gravity, sometimes uses gravity to come back down and land. But it's not obvious. So like this, when we read this document, we are trying to identify the four forces that are there, but may not be obvious. It will not be said in words, but we will try to identify those four words, because what I want to show you is how these four forces are actually working in particular cases in different parts of the world. And since we have some judges from other countries, I thought I'd use one Indian example and one example from another country. This example is only 4 days old. Sir, is it visible now already? Yes.
Yes, it is visible.
Yes. Let me put my microphone on. So, as you can see, this is filed on April 19th. Today's April 25, so it's barely 6 days old. Now, I'd like to look at this first sentence. This gives you in the common law framework, and that is present very much. These two functions are very much present in our system also, except that they're not obvious and they've been merged into the same functionary. So there are two functions here. One is to decide questions of fact. One is to give the rules of law you must apply in arriving at your verdict. So there are three issues actually, not two. Decide questions of fact, give a verdict, and apply rule of law to arrive at that verdict. Sir, I will, with your permission, ask you as a proxy for all the other judges, because of a need for interaction that as you know, I always like interaction. So do you agree that these three elements are present in all our cases also, sir? Can you hear me, sir? Hello.
So your mic is muted. Yelena, sir, your mic.
Sir, your mic is muted, sir.
Sir, please repeat, sir.
Sir, I was asking, the first point I want to make is that there are three core functions that are involved in the judicial process, which are identified in this first sentence. One is deciding on questions of fact. Second, deciding on the rules of law that must be applied. And third, the verdict which results from that. And that is similar to the framework I gave, sir, for under the Evidence Act.
Yes.
Facts, then the connection, which comes from the rules of law, the connections authorized by law. And then from that flows the existence, non-existence, nature or extent of right, liability or disability. So we can see that this is exactly the framework which is in our Evidence Act also. Am I right, sir?
Yes, sir. Exactly.
Yes, sir. Yes, sir. So now the important thing is to understand that in these countries, number 1 and number 3 are in the hands of the jury.
Yes.
Ordinary people, untrained in law, never had judicial experience, no trained judicial instinct, no experience, just walking off the street. They decide on questions of fact and they arrive at the verdict. What is the only function of the judge? It is to give the rules of law that must be applied to these facts to arrive at your verdict, but applied by the jury. That is the special skill and special work on which we have to judge the quality. When we say quality, responsiveness, timeliness and efficiency, the quality part applies to the ability of the judge to accurately give the rules of law you must apply in arriving at your verdict. You must apply. Even the jurors are being told, your verdict must be based on rules of law, not on your instinct. So you're ordinary people. The application is simple. It is not complicated. What is complicated is correctly identifying to you what are the rules of law that you must apply. There judges make mistakes, and there higher courts can declare a mistrial if the judge wrongly instructs the jury on the rule of law that must be applied. There are a couple of issues here which may result in this verdict being challenged, but I'm not getting into that for lack of time. But the higher courts cannot give the verdict. They can declare a mistrial and send it back to a court for a fresh trial. But unlike in our country, the High Court and the Supreme Court or District Court, they cannot appreciate the facts once again, apply the law and reach a verdict. The verdict can only be reached by the jury in a jury trial. So then we understand that the decision making on a case is the least complicated, the most non-expert, the most ordinary, the easiest job in the judicial process. But the most difficult job, and so also finding of facts, easy job, anyone can do it. The most difficult job is to accurately identify the rules of law that must be applied. That is what Mr. Vishal Gogone did. He identified the rules of law that applies to his verdict in a very exceptional way. He did not confine himself to CRPC. He went straight to constitutional principles, and that took him to the Convention on the Rights of the Child and the Juvenile Justice Act, and then he reached his verdict. So you can see Mr. Vishal Gogone doing an exemplary job of the real job of a judge, not to find the fact. Ye kaise aurat hai, what kind of woman is this, what did she do? That's all fact issue. Anybody can find that out. Verdict, bail dena hai ki nahi dena hai, should I give or not give that bail? Anyone can do that. But what Mr. Vishal Gogone did was, he found out the rules of law that must be applied in arriving at his decision in an expert manner because of his superior knowledge. And from there he draws sensitivity. It is not that he is simply being sensitive, but that sensitivity is coming from the law. Remember, he's an agent of the compassion and the sensitivity of the law, not of his own personal conscience, but the conscience of the Constitution and the conscience of the law. So we see that what is exceptional about that judgment, whether you agree or disagree with the verdict, is the fact, is the type of law, rules of law that he invoked to make his verdict. That no untrained juror can do that ever. It requires many years of legal education and legal knowledge and judicial education and judicial knowledge to be able to do that. And that's the first point I want to make on this. Okay, the difference of the role of the judge and the jury. Second point, he now explains what is the role of the jury, which is the easy role. Anyone can do it. Untrained role, illiterate role, legally illiterate role. You have heard the evidence and you will hear the arguments of counsel. I will instruct you in the law. I will instruct you in the law applicable to this case. This is the most important job of the judge, which you saw Mr. Gogone doing. Deciding what is the law applicable to this case. Juvenile Justice Act, Convention on the Rights of the Child. You must follow and apply the rules of law as I give them to you, even if you believe the law is or should be different. This judge is answering many of the comments made in this group. Even if you believe that the law is or should be different, you must follow and apply the rules of law, the right rules of law that apply to this case, which arise in structured reasoning from the issue before the court, from the assertion or denial made in the suit or proceeding of right, liability or disability. It is that assertion or denial that decides what rule of law will apply, right? So Mr. Gogone arrived at these because there was an application for bail by a mother who has a child, and therefore that decision on that bail was what triggered the entire analytical process. Even if you believe the law is or should be different, this is the rule of law. This is the application of the rule of law. And when you see, I believe Indian judges do both jobs, judge and jury. So imagine that this is an instruction you have to give yourself. Because there is no jury, you have to give yourself this instruction. You should tell yourself, I, the judge, will instruct you, the jury, on the law applicable in this case. And you, the jury, you, the person who is finding fact and deciding on the verdict, you will follow the rules of law as that I give you as a judge, even if you believe the law is or should be different. You have each been given a copy of these instructions. I'm not reading the whole thing. You please take these instructions with you and so on. Deciding questions of fact is your exclusive responsibility. So judge is saying, not my job. I have no power to decide questions of fact. In so doing, you must consider all the evidence you have heard and seen in this trial. Imagine this is an instruction to yourself. Don't come to a conclusion. Don't think of victim and society and all that. Just look at facts based on the evidence you have heard and seen in this trial. And you must disregard anything you may have heard or seen elsewhere about this case. And the judge part is telling the jury part. Imagine this as a conversation with yourself. I, the judge, have not intended to indicate my opinion regarding the facts or the outcome of the verdict of this case. So the judge, in deciding the rules of law, must be indifferent to the outcome and the disposal of the case, indifferent, or the facts of the case. There is a suit or proceeding before me. There is a assertion or denial of liability before me or right before me, and for that assertion or denial is based on the following rules of law. Doesn't matter what the facts are, doesn't matter what the outcome is. The assertion or denial of right, liability or disability that is before me is based on the following law, and that law has to be accurately understood and laid down. This is actually an academic function, what academics do. And therefore, I always say that a judicial function is very at the core an academic function, because you must be indifferent to the facts or the outcome and understand the soul and spirit of the law and make sure that that is applied and instructed to your jury part. No, if I've said or done anything that would seem to indicate such an opinion, you are to disregard it. You must consider these instructions as a whole and regard each instruction in the light of all the others. The order in which the instruction, let's leave that. Presumption of innocence. Look at how the Constitution comes straight into this trial. Straight into this trial. The defendant is presumed innocent of the charges made. This presumption remains with the defendant unless and until he has been proven guilty beyond a reasonable doubt. Now, some of the judges here in their comments were they giving? That's a question in my mind. Were they giving enough importance to this cardinal principle? saying that this woman has been accused by the police. She is also a daughter-in-law. Maybe she's done what she's accused of. Maybe she's not. But she is protected by presumption of innocence, and punishing her by putting in jail is unconstitutional. She has to be kept in jail for rational purposes, not to punish her or make the victim happy. This presumption remains with the defendant unless and until he has been proven guilty beyond a reasonable doubt. Until and unless he has been proven guilty beyond a reasonable doubt. That the defendant has been brought before the court by the ordinary processes of the law and is on trial should not be considered by you as in any way suggesting guilt. We violated this principle right now in our discussions. This core constitutional principle, that the defendant has been brought before the court by the ordinary processes of the law. There, of course, there is an independent prosecutor standing between the court and the police. Here it's the police that effectively brings someone before the court, and should not be considered by you as in any way suggesting guilt. The burden of proving guilt is on the state. Another fantastically important principle, the right against self-incrimination, right? The right to silence. Here, with the assistance of many prosecutors and many courts, judges, I won't say courts, because a court is a constitutional activity and prosecutors and judges may not carry it out in accordance with the rules. So many individuals in exercising capacity of prosecutor or judge expects the accused to build the case against himself and says, okay, you now go to jail and then you will confess so that we can then punish you. This is a very basic violation. Sending someone for custodial interrogation is a constantly performed violation of the constitutional right to right against self-incrimination. The defendant does not have to prove his innocence. Of course, there may be shifting of the burden in statutory cases, which is a little more probably common in our country than in theirs, but that's still exceptional in our country. As a general matter, like this woman in this bail order, she does not have to prove her innocence. She's, her being brought before the court by the police is not suggesting that she is guilty. Now, what is proof beyond a reasonable doubt? Imagine this is what a judge is explaining to common people who have no training in law, illiterate in law. And this is what you should be explaining to yourself, you as a learned judge, explaining to yourself as a fact finder. Proof beyond a reasonable doubt is such proof as ordinarily prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. Now here, in this section, we have our own explanation of what is proof beyond a reasonable doubt. It's not fundamentally in conflict with this definition, but we will go by the standards and explained and laid down in our statutes and by our courts. But that is something which you have to remind yourself when you make a decision. Then there is a distinction between direct and circumstantial evidence. That is, the law does not prefer one form of evidence over the other. I'm not going over that. Statements of judge and attorneys are officers of the court. Here we should add statements of the police. That they don't even get to, because the police has no presence in the court. It's the independent prosecutor that comes to the court. And I should mention that, as I said, I have two daughters. My older daughter, for the last 10 years, is a prosecutor in the United States courts, and she is now a federal prosecutor. So I've sat in a court and seen this. The police has no except as witnesses. They have no presence in the court. It's only the judges and the attorneys that speak. And so that's why they're saying here we should add statements of the police. They are not evidence, which may be unless they speak as witnesses. But if the attorneys or I have made or what is introduced into evidence. But if the attorneys or the police or I have made or should make any statement as to what the evidence is that differs from your recollection of the evidence, you should disregard the statement and rely solely on your own memory. Of course, here the police doesn't come. It's only an attorney who could make such a statement to you. But if anyone makes a statement to you, you should not go by that statement. You should only go by recollection of your evidence. Again, a very important constitutional principle. Multiple charges, definitions of words and phrases. I'm not going through that. That is based on their own law. The jurors are instructed on what is attempted, what is bodily harm. Now, but here you have to, when you are a juror, you are functioning, not you're a juror, you're undertaking the fact-finding function, the fact-finding and verdict decision function. You must lay out the elements of the law, the requirements of the law, and I'll come to that. First you have to start. I call this normative judgment. So disregard the content of this, but the procedure is very important. That you first start out by saying you have asserted a right, liability or disability, or you have asserted a liability of the accused to be jailed, or in this case, to be convicted of murder. And for that, what are the requirements? What are the ingredients? What is the hypothetical fact pattern? What are the ingredients that need to be proved for your claim to convict and punish this person to succeed? So that's what this judge is doing. He's laying down independently the ingredients. He is now telling them what the law is. So this is what bodily harm means. This is what causing death means. This is what knowledge means. This is what intentionally means. Remember, he's not starting with the facts. He's starting with the principles of law. This is the law. With intent means this. Police officer means this, right? Then after having laid down the principles of law by which the guilt or innocence must be proven, he'll get into further details of that. He now goes to the details of the law, principles of law. So he says the defendant is charged with, so the state is demanding, asserting the liability of the defendant to be convicted and punished for murder, right? Murder in the second degree. And then he explains what is murder in the second degree. The judge explains a person causing the death of another person without intent to cause the death of any person while committing or attempting to commit a felony offense is guilty of the crime of murder in the second degree. So you have to also commit a felony offense, and then you go into the second degree murder, right? The defendant is charged with committing this crime or intentionally aiding the commission of this crime. Then he goes into the elements of the law that have to be proved in order for the claim or the assertion of the state that he should be convicted and punished of second degree murder can be proved. What are those elements? The first element is the death of George Floyd must be proven. He's now given the definition, but he's breaking it down. The second element is that the defendant caused the death of George Floyd. The third element is the defendant at the time of causing the death was committing or attempting to commit the felony offense. There are two elements of, and then he says the next charge is assault in the third degree, and he says these are the elements of the assault in the third degree. The fourth element is this. Then he says, if you find that each of these, this is count one, each of these elements have been proven beyond a reasonable doubt, the defendant becomes guilty. There is no discretion. Necessarily follows. If he says these by elements, he says, look, these are the elements that require to be proved for guilt. Fact in issue are facts which show that these elements are satisfied, from which the liability to conviction and punishment necessarily follows. So if each of these elements has been proved, each beyond a reasonable doubt, not cumulatively, the defendant is guilty of this charge. If you find that any of these elements, any of these elements has not been proven beyond a reasonable doubt, the defendant is not guilty of this charge. Even if you find only one element not proved, he's not guilty of the charge, unless you find the state. And then he explains the liability for crimes of another. The defendant is charged in count with murder in the third degree. He repeats the same thing. He explains the next count, and then he says what is the definition. what are the elements, what needs to be proved. But remember, he's starting, tell the jury first be aware of the legal standard and then see whether the facts meet the legal standard or not. Then he gives the definition, he gives the elements. So again, this is structured thinking. This is legal reasoning. This is judicial reasoning. A lay person will say, oh, what happened? Oh my God, starts with the facts. Oh God, she hanged herself. My God, she got beaten. My God, she got this. Okay, who is the father? Who is the mother? Or the other way around. Oh, father, mother could not have done. Whatever it is. Whenever I find that whenever we first go to facts, as human beings, a moral judgment emerges in our mind, whether we like it or not. In all our minds, a moral judgment emerges. I know this person must be guilty. I know this person is a bad person. It looks like a bad person to me. Someone told me, sir, I've been a judge for 25 years. I know when somebody's lying. I said, I accept. But what if this man has been lying to judges for 35 years? He knows how to lie to a judge better than you know how to figure out if he's lying. So we can't go to these personal judgments. We have to look at the evidence, the material before the court, and based strictly on the evidence, not on a personal sense of instinct. We have to say, does the evidence actually prove beyond a reasonable doubt the element that is required to be proved? Structured thinking, not casual thinking. And if we start with the elements, and then this is what I call normative judgment, a method of judicial decision making, which is used internationally and in our country by several judges. They start with the element, what is the assertion by the before the court? What is the assertion or denial before the court of liability, of right, liability, or disability? And if that, and to prove that assertion, what are the ingredients of law that have to be proved? Then what are the relevant facts in issue? Are only facts in issue from which this liability necessarily follows. Only take evidence on facts in issue and relevant facts and nothing else. And divide that evidence between what is admitted and what is contested. So actually what is admitted, there is no need to take evidence, it's already admitted. So then you confine evidence only to what is contested. If these ingredients, if there is evidence, including admitted and proven through contested evidence, beyond a reasonable doubt that these elements are satisfied, then the liability asserted to quote the Evidence Act necessarily follows. It's a very beautiful structured way of thinking. Of course it is done subjectively because the law has to be, like you've seen in Mr. Vishal Gogone's case, subjectively, because of his knowledge, because of his understanding, his mind brought in relevant laws and stated the principles of law in a much broader, more comprehensive, more accurate way than many of us would have. Maybe I would not have done it if I were in that place. And then he looks at what are the facts in issue relevant to make that decision, not a verdict, to make the decision on giving bail. So this sequence of not starting with facts and then seeing what the law is, in which case the huge amount of evidence will be introduced, and that affects efficiency of the court and wastes court's resources. But if you start with the elements required to be proved for the assertion or denial of right, liability, or disability to succeed, and narrow yourself to facts in issue, narrow yourself within that to contested facts, then you will find that the whole exercise becomes much more under control and the structured reasoning will lead to its own conclusion. Then evaluation of testimony, believability of witnesses. You are the sole judges of whether a witness is to be believed and of the weight to be given a witness's testimony. This is the standard of proved fact. There are no hard and fast rules to guide you in this respect. An honest statement that belief is not based on hard and fast rules. That is why they have 12 people who must unanimously believe before somebody is punished. Here, we have to only convince one human being. When there are no hard and fast rules to guide what is belief, the belief or otherwise of one human being will lead to conviction. I don't think this is a good system. I think this system has to change. When 12 people are, after listening to the same evidence, unanimously, not by majority vote, even if one person doesn't believe, then that person cannot be convicted. Because what is precious as the Bombay Civil Court judge realized when he was put in the dock, what is precious is liberty. What is precious is a presumption of innocence, the right to a fair trial. Unfortunately, it was denied to him by the system, and when finally he got it, it was too late, and he died. In determining believability and weight of testimony, because he lost his job, and he suffered all this because somebody believed the what can I say, tailored statements made by the police against the judge, and not the full scope of the statements. And that was the basis on which action was taken against him. In the ultimate trial, the full facts came out, and he was acquitted. But as I said, it was too late. So you may take into account interest or lack of interest in the outcome of the case, of the witness, relationship to the parties, ability and opportunity to know, manner, age and experience. Now, this list can be your own list. It can be any reasonable list, relevant, taken from our own judgments. But you can make a list of what are the factors that you should look at, because you are bearing this huge burden of deciding facts all alone. When there are no hard and fast rules, as this court honestly says, very few judges in this country will admit that belief is very subjective, and there are no hard and fast rules. And that is why they say any ordinary person can do this. Right? You should rely in the last analysis upon your own experience, good judgment and common sense, all 12 of you. Then there is expert testimony. You should look at the education and ability of the witness, reasons for the opinion, sources of information, and such other opinion. Defendant's right not to testify. The defendant has no obligation to prove innocence. Defendant has the right not to testify. The right is guaranteed by the federal and state constitutions. So you can see how in every single case constitutional rights are being asserted. You should not draw any inference from the fact that the defendant has not testified in this case. Impeachment is disbelieving a witness. Evidence of any prior inconsistent statement or conduct should be considered only to test the believability and weight of the witness's testimony. You may, for this purpose, consider evidence of a statement by or conduct of the witnesses on some prior occasion that is inconsistent. Evidence of other occurrences involving George Floyd. This evidence is not to be used as evidence of the character of George Floyd. You have heard evidence of an occurrence involving George Floyd on May 6, 2019. As I told you at the time of the evidence, it was admitted solely for the limited purposes of showing what effects the ingestion of opioids may or may not have had on the physical well-being of George Floyd. But it is not to be used as evidence of the character of George Floyd. Demonstrative evidence, definition of words, ruling on objections to evidence, right? I have ruled on objections to certain testimony and exhibits. You must not concern yourself with the reasons for the ruling, since they are controlled by rules of evidence. By admitting into evidence testimony and exhibits, I did not intend to indicate the weight to be given such testimony and evidence. You are not to speculate as to possible answers to questions I did not require to be answered. You are to disregard all evidence and statements of lawyers that I've ordered stricken or I've told you to disregard. These are the principles that govern structured reasoning. This is the structured reasoning that we mean by judicial reasoning. Jurors may return notes taken by jurors. You have been allowed to take notes during the trial. You may take these notes to the jury room. You should not consider these notes binding or conclusive, whether they are your notes or of another. They should be used as an aid to your memory and not as a substitute for it. It is your recollection of the evidence that should control. Implicit bias, very important. We have implicit caste bias, communal bias, gender bias. All human beings have implicit bias. I have implicit bias, but we should be conscious of it. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of and others we might not be fully aware of, which is why they are called implicit or unconscious biases. How many judges ask themselves in a case? I know many do. I know as a fact that many do. But I'm asking how many judges ask themselves when they are fact finders, am I affected by implicit bias? I know there are judges who consciously do that, and they're wonderful judges, but I think this should become standard practice. No matter how unbiased we think we are, our brains are hardwired to make conscious, unconscious decisions. No matter how unbiased we think we are. Our brains are hardwired to make unconscious decisions. That is why we need structured decisions and to eliminate subjectivity. This is why we are getting a lot of divergence in judging, because we are not taking adequately in a scientific manner, consistent manner, with a consistent methodology these factors. We look at others and filter what they say through the lens of our own personal experience and background. Because we all do this, we often see life and we evaluate evidence in a way that tends to favor people who are like ourselves or who have had life experiences like our own. We can also have biases about people like ourselves. One common example is the automatic association of male with career and female with family. Bias can affect our thoughts, how we remember what we see and hear, whom we believe or disbelieve, and how we make important decisions. As jurors, you are being asked to make an important decision in this case. You must take the time you need to reflect carefully and thoughtfully about the evidence. This is applicable to you as a judge when you are finding facts and deciding on verdict. Take the time you need to reflect carefully and thoughtfully about the evidence. Think about why you're making the decision. This is what I say. Justice gives you the answer to why you're making the decision, and examine it for bias. Reconsider your first impressions of the people and the evidence in this case. The people involved in this case were from different backgrounds, for example, richer or poorer, more or less educated, older or younger, of a different gender, gender identity, race, religion, or sexual orientation. Would you still view them and the evidence the same way? Listen to one another. That's for jurors. You don't have that opportunity. Resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes. The sympathy must be structured in the law. Stereotypes are unconscious biases. The law demands that you make a fair decision based solely on the evidence, based solely on the evidence. Your individual evaluations of that evidence, your reason and common sense and these instructions, right? Common sense is again not a free authority to you what you want. Common sense is on how you deal with structured reasoning, not to go outside it. All this decision must be based solely on the evidence proven beyond all reasonable doubt in front of you. Then selection of 4 persons, I'm leaving that internal working of the jury. Then finally the judge says, now members of the jury, this case is in your hands as judges of the facts and the verdict. I'm certain that you realize that this case is important and serious and therefore deserves your careful consideration. So here is an example of how the four forces of justice, of the justice system, constitution, ideas of justice, including fairness, including equality, including lack of bias, and all these ideas, the ideas of rule of law, the structure of the decision-making process, and reasoning, all are combined and applied and operated in a manner that will ensure that the decision, the judicial decision, is consistent with the structured decision-making process. Makes it a very sophisticated, scientific way of deciding. And if you follow this, I think we will be able to, frankly, save a lot of time, improve a lot of quality, and protect the fundamental forces, the 4 fundamental forces in which the within which the judicial system operates, and be able to comply with our obligation to promote justice. Sir, I'm going to stop here and get some reactions from you, some reactions from others, and I'll impose on you for this, sir. What? Yes. Yes, sir.
Sir, thank you very much, sir. If you please, you can stop sharing this.
Yes, sir. Yes, sir. Yes, sir. Yes, sir. Yes, sir. Yes, sir. Yes, sir.
Thank you, sir. Sir, one question received from Justice from Sri Lanka, and similar question was posed by many other participants. This is with relation to the judgment given by Justice Gogne, sir. The question is, if the mother is found guilty on trial,
Yes.
how would you suggest to apply the child's rights?
Yes. Sir, Mr. Gogone, Judge Gogone deals with this at the outset of his judgment. He says we have in the Constitution the concept of liberty and the rule of law. Today, well, for an under trial prisoner, it should be reconciled in this way because there is no evidence given to him by the state or no material given to him by the state to show why this woman should be kept in jail other than the accusation is serious. That's only one element, but no other element is given. So he's able to reconcile these two principles in this manner. Once she's convicted and she becomes a prisoner. Then she moves to a different field, and there is a lot of science, sir, on dealing with what to do with children of convicts. In proper jails, once they are convicts, they are in jail. There's a lot of attention to this issue because many prisoners all over the world have little children. So, and we have to look at the family circumstances. Are the grandparents available? By then, now criminal trials are moving fast, but the child will be older, not 21 months. So we'll have to look at the age of the child at that point of time. Child may start going to school. So we have to look at where the child is going to school. So we have to look at the facts and circumstances of the case and decide what is in the best interest of the child while respecting the obligation, the liability of the woman as a convict, not as an under trial prisoner, as a convict who has been found guilty and is undergoing punishment, to undergo that punishment. And then we can, the judge can call in the jail authorities and point out national or international best practice on how you deal with children who are in prison of convicts, and ask the jail to deal with this child in the best possible way. Find out from the mother and the family what is the best way to deal it, because it is how to protect the best interests of the child. Sir. Right now, this is the best way to protect the best interests of the child. But if there is conviction, depending on when that happens, that issue will have to be considered again. And Mr. Gogone begins by acknowledging this conflict, begins by acknowledging this, the need to reconcile. It's not a conflict, but the need to harmonize two goals, which are both of which are part of our framework of four forces: rule of law and justice, liberty as a part of justice, and part of the objectives of the Constitution. So both liberty and the punishment, if she is convicted, are both important to create a fraternity and a friendly society, sir. Both are required because you cannot let this kind of inimical action go without some kind of correction and some kind of protection. So ultimately, all these actions are seeking to promote fraternity, so that in a highly conflict-ridden, diverse country, we have only two choices. Either we burn, like Afghanistan and Iraq, through uncontrollable conflict, or we create a new order based on fraternity and mutual support and cooperation. So all of these interventions must only, and that is like gravity. There is no alternative to that, sir. You cannot violate that principle. But what is the best way to do it? Because if this woman is guilty, she has seriously, grossly violated the principle of fraternity. Assuming that the charge is correct, I'm not saying it is. She has murdered her sister-in-law, or helped in murdering, or whatever the accusation is. I have not seen the charge sheet. So that's a very serious attack on the issue of fraternity. If that is proved beyond reasonable doubt in a fair trial, then fraternity demands that that person must be held to account, so that we send a signal to society that that kind of conduct is wrong conduct, it's not right conduct. So we'll have to, this is the challenge, sir, where we will, I'm sure, find, and people like yourself, I know, sir, from personal experience, and Mr. Gogone, will find wonderful solutions that I'll be able to talk about in future sessions.
Sir, after your session, not just two, sir, hundreds and thousands of judges will follow this path, sir. I'm sure, sir. Sir, one question has frequently appeared, sir, with reference to the jury. So the question is, if the jury has to follow all these instructions, then
Yes.
what is the difference between jury and judge? That is the question, sir. And the connected question is, why this jury system has been abolished after the Nanavati case? But before requesting you to take up this question, sir, I would like to bring to your notice, sir, Section 299 of
Yes,
the
sir.
old CRPC, sir, not
Yes, sir.
the new one, sir.
Yes, 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 sir.
So I have shared it on WhatsApp also for ready reference, sir.
Yes,
It
sir.
says, sir, it is the duty of the jury to decide which view of the facts is true
Yes.
and then to return the verdict which under such view ought,
Yes.
according to the directions of the judge, to be returned.
Yes, sir.
This was the section under 290, section of 299 of CRPC, old CRPC, 1898, sir.
Yes, sir.
So I believe that the similar principle must be in existence in those countries where this jury system exists.
Sir, the direction of the judge is only on that this judge has also said, sir, it is only on what are the rules of law to apply.
Yes, sir.
What are the rules of law to apply? Not on the verdict or not on the facts. He has said, look, verdict you will decide. Facts, whether to believe or not, you will decide. But the law, see, sir, the sequence is the rules of law decide what are the elements that require to be proved. What are the rules of law? So first there is an assertion of a liability to punishment. That assertion of liability to punishment is based on law. That law requires certain elements to be proved in order for that assertion of liability to succeed. So what the judge is advising the jury is, these are the elements of hypothetical facts that have to exist if this liability has to be attached to this person, namely imprisonment. So those elements, what has to be proved, is given by the judge, is directed by the judge. That is what we mean by the law. What has to be proved for conviction? Now, then the evidence is heard by the jury decides whether to believe or not, and when the jury decides on belief or not, then the verdict automatically follows. The verdict is not the punishment, but when all the elements are satisfied beyond reasonable doubt, the verdict automatically follows. In some countries, the punishment is also decided by the jury. Not in all countries or in all cases. In many cases, the judge decides it. The question is, what is the difference between the judge and the jury, sir? It's precisely this. Only Mr. Gogone, as a judge, can and could tell a jury, suppose this was a jury case, that you must consider the Juvenile Justice Act before deciding whether the liability of imprisonment as an under trial can be attached to this woman. Jury has no option. They have to consider the Juvenile Justice Act. The judge tells the jury, you may believe that Juvenile Justice Act has no relevance. You may believe that it's not a good act, but you have no choice. If I tell you that the Juvenile Justice Act, the principles of the Juvenile Justice Act must be applied in deciding whether or not this person, the verdict is this person must go to jail. In other words, if the following elements are satisfied, automatically she goes to jail. In those elements is, I'm including the elements from the Juvenile Justice Act Section 3 that you referred to. The jury cannot say, no, we don't agree. We won't look at that. They have to follow that. But the decision on whether the facts are proved, whether to believe the evidence, is only made by the jury. And when on the elements prescribed by the judge, the evidence is presented beyond all reasonable doubt, then, sir, the verdict automatically follows. That is a big difference, sir, I say, between our approach and this approach. That here the verdict is very often seen as a exercise of the judgment and discretion of the judge. Whereas if you break this down into the elements, as this judge has done, and then you put on the juror hat, and you ask, are all the elements proved beyond all reasonable doubt? Then where is the discretion, sir, on the verdict? Where is the discretion on the verdict? So this whole idea, sir, that I will listen to the evidence and then decide whether a person is guilty or not is actually the old Raja era judging, sir. This Dushta Danda Sajana Puja Rajya Kosha Vriddhi Rajya Raksha, sir. What I call DSKR, principle of justice, role of justice. DSKR, Dushta Danda Sajana Puja Kosha Vriddhi Rajya Raksha. You know, that is no longer the role of the judge, sir. Now the role of the judge is to uphold justice, promote justice. Justice means right conduct. Right conduct is not just Dushta Danda, Sajana Puja, Kosha Vriddhi, Rajya Raksha. Dushta Danda, right conduct is equality, freedom, equality, liberty, fraternity, dignity, rule of law. And rule of law reasoning is the method we reach those conduct. But these four core principles, sir, fraternity, dignity, equality, liberty, this right conduct that supports and promotes these four values, that is today right conduct. That is justice. That is justice. If any judge makes a decision that harms or does not promote these four values, that is injustice, sir, today. Injustice.
Sir,
Injustice. Yes, sir.
Respected participant wants to know
Yes,
whether
sir.
Dushta Danda Sajana Puja Kosha Vriddhi Raja Raksha is from any book or your thoughts?
No, sir, not my thoughts, sir. Not my thoughts. It is based on actual scholarship and actual framework. Some scholars have said that, and that was actually the expression of the duty of a Raja as a judge. The duty of a Raja as a judge, because judge was a Raja, sir. There was no black robed, separate, independent professionals. There was no independence of the judiciary. One question yesterday came up on independence of the judiciary and these four fundamental forces that uphold the judicial system. Sir, the independence of the judiciary comes from these four forces, sir. Sir, if a judge goes by these four forces and the logic of these four forces, that judge is independent. No one will question that judge's independence or integrity, sir. And it is only when subjectivity comes in that people start to question, because judges are our agents, sir, not our rulers. We don't want the agent to boss us, sir. We want the agent to do what we have told the agent to do. When the agent starts to act as the owner, I give power of attorney to sell my house, and he starts to reconstruct my house and bring in new tenants and put a new floor. I'll say, what is this? I gave you power of attorney to be an agent to sell my house. Now you're changing my house. That is the reaction of people, sir, in a democracy, when judges start telling us what is right, what is wrong, what is good, how you should improve, how you should correct yourself. We don't want you to tell us, sir, that the legislators are telling us. So, through law and through the constitution. Your job is simply to ensure that these four forces are protected. These are the four fundamental forces that safeguard justice.
Sir, is the verdict of the jury binding on the judge?
Yes, it is binding on the court, sir. It can only be challenged on the basis of mistrial, sir. Mistrial. It is absolutely binding. The verdict cannot be changed. Judge can declare a mistrial. If the judge finds that there is no basis for the verdict, these instructions he has given to the jury have patently not been followed, he can declare a mistrial. In fact, there was a very interesting moment, sir, in this trial, George Floyd trial, when at the last minute, the prosecutor introduced a witness who said, sorry, not the prosecutor, sir, forgive me, the defense attorney, he brought in an expert witness who said that this man was being pinned down and the knee was being put on his neck, right, you may have seen, sir, at the rear side, almost below a police vehicle. That police vehicle's engine was running. Carbon monoxide was coming out of the exhaust pipe. So this expert witness said that he died because of carbon monoxide poisoning, not because the judge, the policeman put his knee on his neck. So then the prosecution said, we want to counter this because we have evidence showing that his blood oxygen level was high. After, even at the time he died or around that time. So he could not have had carbon monoxide poisoning because his oxygen levels were high. Or whatever, they had evidence to contradict that. The judge said, no, you cannot introduce that evidence. Why? Because the judge said that, look, there is no surprise here. Every witness's name and what the witness would testify was shared between both sides early on. You knew that this witness will come and will say this. You had a chance to contradict this evidence before, when you led your evidence. You did not do it. Now you cannot have a second chance. And then he told the prosecution, if you even suggest that there is material to contradict this in your closing arguments or in any other way, I will declare a mistrial. So the judge can declare a mistrial, but cannot, the verdict is only, sir, the one of the great judges in the UK said that if a dictator comes to UK, he will do two things, or she will do two things. One is shut down parliament, and the second thing is to shut down the jury system. And he said, because the jury system is the lamp that shows us that democracy is alive. That common people are making the most important decisions on whether someone is guilty or not, because we recognize that there is no science to this. And the judges may pretend there is a science, but the fact is there is no science. It is a subjective decision, subject to all the biases, prejudices, and disadvantages that this judge has identified in his instruction to the jury. That is compensated by having 12 jurors and telling them that if 12 people unanimously agree that the elements have been proved beyond reasonable doubt, then the verdict of guilty automatically follows. That's a protection, sir, of liberty and freedom. And so this is a very sacred and precious part of the constitutional structure. And I'm personally very much in favor. There are a lot of deficiencies, sir, as we have seen during the Nanavati case. There are a lot of deficiencies to the jury system. There are a lot of deficiencies to the bench trial system. I'm not saying it's perfect. But because there is bad food and I may get ill eating some bad food, can I say I won't eat again in my life? I have to eat, sir, because I cannot live without eating. Similarly, liberty is important, sir. It's like gravity. I cannot violate that. We cannot live without liberty. We will die. So even if liberty has negative consequences, even if jury system, which is an essential part of liberty, has negative consequences, we have to do the best we can.
Sir, I would like to share what our former director, retired Justice Sri V.M. Kanade has shared after his interaction with the visiting Chief Justice of China.
Yes, sir.
Our Lordship asked whether your jurisprudence also follows the principle that a person is presumed to be innocent until the offense is proved. He said that the visiting Lordship said that we also follow it, but with a later variation. A person is innocent until police arrest him.
Yes. Well said, sir. This is pretty much what is going on in our country also, sir. Not just now, from the old pre-independence days, sir. From pre-independence days. That the moment police arrest him, people, we assume that there is something that he has done wrong, sir. Until Gandhiji was arrested and put in jail, then people started to doubt maybe good people are arrested. That doesn't mean, sir, all the arrested people are good people. A lot of bad people are genuinely arrested. I'm the son of a police officer. I can tell you, sir, the bad people, there is crime. There are a lot of anti-fraternal people, but we have to deal with them through the rule of law, sir, and protecting liberty. and protecting these fundamental forces. We cannot deal with them like China. Sir, China usually, sometimes it takes 1 week, 2 weeks, sir, between arrest of police and execution by firing squad, sir. 1 week to 2 weeks. Now, if that is the kind of justice we want, after that, is there corruption in China? Yes. Is there misconduct in China? Yes. So what do they gain by that, sir? So I think we have some ancient values. We are not imitating any system. We have some ancient values that respect each other's humanity. The famous story of Shankaracharya asking a Dalit to move aside, and the Dalit asking him, "Are you asking my body to move or my soul to move?" Because he was untouchable. And Shankaracharya apparently bowed to him. So we understand, sir, that ultimately the soul is free, the spirit is free, whether you believe in soul or not. The energy that is all of us is free, and our job is to protect that freedom and to respect that freedom, and it exists in all of us, sir. It is not that that energy is given only to people of privileged birth, and the rest are all pieces of wood. And so that these fundamental principles of the Constitution are very much part of our very ancient realization, sir, from our tribal people, from our Dalit communities, that respect, because they've been through a lot. They respect their culture, not every individual. Respects the humanity and spirituality of all of nature, not just human beings, of all of nature. And that is what we share in the subcontinent. So whether it's Nepal, Sri Lanka, Bangladesh, Pakistan, we all share that understanding. And we are now simply talking of how a legal system can be more in tune with these four fundamental forces that freedom. Sir, I have to move, sir, to this this court management aspect, sir.
Yes, sir. Yes.
I shared with you my questions from yesterday, sir, on WhatsApp. You have seen it, sir?
Yes, yes, sir. I have it. Yes.
So the main I have sent Sudhakarji the over 200 questions that came yesterday.
Yes.
I have organized that into
12.
Into 12 subheadings, and I will just briefly summarize to see whether, because we have gone through the two we have gone through the two. One second, sir. The two cases that I wanted to go through, and so I will just look at this. So the first are conceptual issues. A lot of questions about justice, social justice, and I think there is a struggle in our mind between, as I said, justice as revenge, justice as order, justice as distribution. These are all old ideas of justice, and which are very powerful inside our subconscious mind, in our social mind. There is no doubt that the Constitution has come up with, and I'll conclude with putting on the screen Justice Butt's understanding of the Grundnorm of the Constitution as fraternity. It's a very, very different idea of justice, the justice as fraternity, and as right conduct. And so there is a Mahabharat going on in our minds, sir, which we are resisting a new idea. But our job in Judicial Academy, sir, is to bring about, as Justice D.A. Desai said in the 117th report of the Law Commission, Justice D.A. Desai said that we need judicial academies to bring about this transition from judiciary being simply an extension of the law and order machinery, worried about rising crime, worried about conviction rates, worried about punishment, to being, as Justice Desai says, sentinel on the qui vive, sentinel on the alert, protecting these fundamental rights and values of the Constitution. So he said we need judicial academies to bring about this transition of the especially district courts, which were not part of the judiciary, sir. They were part of the executive till 1950. And so they have now become part of the judiciary, starting with JUS. Otherwise, they were just courts. Now they're part of the judiciary, which is a system of upholding norms of conduct. That's why it starts with the word JUS. It's a system for upholding norms of conduct. And so now their job is to uphold the norms of conduct prescribed in the Constitution. So so a lot of questions around that. Someone asked me, injustice anywhere is injustice everywhere. Can you explain that? And I think that's a very good question. It simply means that when somebody believes in the wrong way, then the people who are watching that doubt whether there is a right standard or not. And soon they start to imitate because they lose faith and credibility in what is the right conduct. So if there is let's say a teacher who's beating up students a lot, then other young teachers will come and say, if he's a senior teacher, maybe it's right to beat up children. They'll also start beating up children. So if you understand justice is right conduct, injustice is wrong conduct. And as for us in the Constitution, justice is fraternity and all that goes along with it, the whole package that goes along with it. Then if you allow other conduct to go on uncorrected, then it will spread. And that's what is meant by that, sir. Justice, sir, the justice, why is justice done by so-called lower courts overturned by higher courts? Because the lower courts may or may not have appreciated what is these four forces correctly, sir. They may not have appreciated what is the nature of the Constitution, that it is not simply a governing document. It is a governing document, but it is also a document that sets out a Grundnorm. And that Grundnorm is a Grundnorm of constructing of an agreement between people on how they will treat each other. So if the court does not understand, that has to be corrected. If the court does understand justice as DSKR, Dushta Danda and all that, DSKR, or the order or distribution and all that alone, then that has to be corrected and it has to be aligned with justice as constitutional values, namely equality, liberty, fraternity, dignity, and only a intervention by courts to uphold this conduct in real life will be seen as justice. So these things have to be corrected, sir, as we move forward. That's why sometimes in the best case scenario, the changes take place. But sometimes, as we have seen in ADM Jabalpur, even the Supreme Court makes mistakes. Supreme Court itself has said we are supreme not because we are infallible, but because we are the final court, that they also make mistakes and then history corrects them. People like us as academics who have no stake, who don't make a living out of the system, we also have a role in correcting the what we think are to put that argument before the courts and the public about where the courts may be going wrong. One question, explain the correlation between artificial intelligence and physics of justice. There's no correlation. Artificial intelligence is simply automating the human actions, copying and automating human actions. So that they can be automated. Physics of justice is just a metaphor I'm using to make us understand that there are fundamental forces. Physics tells us about fundamental forces that govern all our lives. We are talking to each other because of fundamental forces identified by physics, but they're not obvious to us. We don't talk about them, but we cannot violate them, and without them we can do nothing. So similarly, I'm arguing that there are four fundamental forces that under which the judicial system operates, without which the judicial system will collapse, and you cannot violate these fundamental forces. If you do, you will destroy the system. Like if a plane violates gravity, it will crash, guaranteed. So my effort is simply to use the phrase physics of justice to attract attention to the four, what I call fundamental forces that underpin the judicial system. Then we have a lot of questions on application, sir. Hire purchase agreement, committing murder, and I think after going through these two cases in detail, sir, about how these four principles are applied in particular cases, I think hopefully the questions may not be answered, but certainly my answer has been given, imperfect as it may be, through these case studies. Then what is the role of the court? Adjudication versus justice. Sir, adjudication also, at the root of adjudication is JUS. It is a process of determining what is the right conduct that should be applied in a particular situation. So there is no contradiction between adjudication and justice. There is a contradiction between bureaucratization and judging. I often ask judges, what is the difference between a district collector and a district judge? Judges are not bureaucrats. Bureaucrats are executing a task and the executive branch. They're given a task, they have to do the task. They have some rules they have to follow, they have to take some steps, and they have to get results. They have to obey whatever they're instructed to do. The judicial function is very different, sir. The judicial function, as we've been discussing since yesterday, is about upholding right values of conduct. The most important, most complex, most challenging task of society. We face it when we raise children. We face it when children face it when they raise us as parents and we misbehave. I have two daughters, I can say, sir, they raised me more than I raised them, correcting me. So we understand when we have to correct each other how difficult it is to define what is right conduct and to persuade people voluntarily to do the right thing. And here the Supreme Court has given us a very clear standard, sir, very simple standard. Build a society that is based on fraternity. Otherwise, we will go down in flames in this country. We will be destroyed. We cannot afford conflict. We have too many differences. We cannot be homogenized. We cannot be made uniform, no matter who tries. Many people have tried it, sir. All failed. We can only be made friendly to each other with all our differences. That's what the Constitution wants us to do. So our very important job in the judicial and legal system is to be clear about what is the right value and to promote it. Now, we alone cannot bring it about, but we can contribute. So when there is a slum in which a woman goes to, children go to sleep every night hearing the screams of a woman being beaten up by her drunk husband. And suddenly one day there is silence in that slum because the woman is not screaming. And next day everyone asks, why was there silence? And the woman says, because there is a magistrate who applied the Protection of Women Against Domestic Violence Act and used the instruments given by that act to ensure that this man doesn't beat me up. And so last night I was not beaten up. And so I did not scream. Then everyone in that slum understands, through the silence in that slum, they understand that the Indian state, acting through its agent, the magistrate, the junior division judge, has said that it is wrong to beat up your wife. And the state will intervene if you beat up your wife. And that will send a signal not only to other husbands, but also to young boys, 5- and 6-year-old boys who are growing up. They will realize, no, it is wrong to beat up your wife. So every decision that a judge makes, and I have some judgments. One judgment issued by a magistrate in Singapore on a traffic offense, which actually discusses this. Many such judgments. Judges need to be aware that every judgment you make, whether you like it or not, is not a bureaucratic task to be disposed of within time, without looking at whatever needs to be looked at, dispose of it. It is a lesson to society about what is right conduct and what is wrong conduct. I have seen a man being remanded in Trivandrum. I went and talked to him some time ago. And he said, the policeman who brought him to jail said, this man is innocent, sir. This man has just been picked up because somebody had to be picked up. He said, I'm innocent. He said, if the judge looks at the case diary, looks at the control room records, he will see that this whole thing is cooked up against me. But he will not look at it. He said, here, the practice is I will be remanded twice and then I'll be given bail. So today is my first time. I will be remanded. And I had a legal aid attorney. He will not talk to me, and the judge will not talk to me, and I will be remanded. That's exactly what happened. Sir, a judge should only send a man to jail if you would send your own father or mother or son or spouse or yourself to jail, even for 1 minute. Because everybody is somebody's son and somebody's sister, no matter how evil, whatever, there is a family involved. So by all means, send remand him, but pay attention, as Mr. Gogone has done, to the facts and circumstances. Don't say, I have no time. What if somebody sends your mother to jail, remands your mother? on the basis that he has no time, innocent mother, on the basis that he has no time to look at the material, will we accept it? So we have to realize the gravity, as the judge, this George Floyd judge said at the end. Please understand that the decision to the jury, please understand that the decision you're about to make is a very important decision. The greatest power of the Indian state, other than death sentence, is to take away liberty. And it is done so casually by remand, by rejection of bail petitions, so casually. The greatest power, it is the atom bomb. The second, one is like hydrogen bomb, the second is atom bomb. This remand and denial of bail is the atom bomb power of the state, so the biggest power of the state, with huge consequences, where people will say this man was sent to jail, he must be a bad guy, he must be a criminal. The kids will not play with his children. The women will not talk to his wife. Huge social consequences. So by all means, if the law demands that must be done to uphold fraternity, somebody has to be remanded, remand by all means. But observe this, reasoning, structured reasoning, remove subjectivity, apply your mind, think of all these dimensions as Mr. Gogone has done, and then make that decision. So the job of the judge is to make sure that the right values are upheld. It's not a bureaucratic job. In the old days, I would say it is a job of a rishi. You go to a rishi and say, decide what is right conduct and decide, what should happen to people who engage in wrong conduct. Rishi above religion, above caste, above all these things, detached somewhere, only focusing on what is right conduct and wrong conduct. That kind of rishi, not the politician kind of rishi. And then that person will uphold the right conduct. So your job is to uphold the right conduct, sir. And I'm afraid a lot of people are seeing it as a bureaucratic task, simply task. Dispose realities. We have got too many cases. If my mother was sent with because some doctor, she died because some doctor said, look, I have no time to examine you. I would not, no matter how, and the doctor is busier than a judge, sir. Most doctors are busier than a judge, much busier than a judge. But he doesn't examine my mother and my mother dies. I don't think I'll be able to accept that excuse that he was too busy to examine my mother. And so I think the job is so tough. If you cannot do it, sir, you should leave. And let others, and there are many others who never say that it is there's no time, who are able to do this job very well in the judiciary. But anyone who says we cannot manage this very important function because there is no time, actually should not be doing this job, because it comes as a huge cost to human liberty and human freedom, and the fundamentals of the Constitution are being very seriously damaged. Blending adjudication and conciliatory processes. They are two different things, sir. Yes, courts can do both, but please understand the difference. The adjudication, the judicial function, as I said, is about the use, about the standard of human conduct, rightness of human conduct. But where there is no dispute about what is right conduct, and there is a dispute on facts or a dispute based on ego or something else, then that can be decided by adjudication not by adjudication, by mediation or arbitration. And I think we have developed good systems for that purpose. There's a question: how can fact-finding trial courts apply these values? I've given you two examples of trial courts in detail applying these values. I've talked about discretion. I've talked about rule of justice, law and justice, and I have explained that rule of law lies actually in the heart of the rule of law lies in the process of it lies in the technology of reasoning, structured thinking. And I've said that there is structured thinking is less in subjectivity, is much more objective, and in the context of the law and justice system, there is a specific technology of structured judicial thinking, which is what I said, that it has the 3 points on the concept of facts, the Evidence Act concept of facts and proved facts, on the way of connecting, the law connecting, not the arguments of the parties, how the law connects the facts together to determine whether there is right, liability or disability that follows from the law. So these 3 elements together are at the heart of judicial and legal reasoning. and this connections between facts must come from the ingredients of law and not from, because laws are hypothetical facts and not from our conscience or our gut instinct, or which is or our personal experience, which is what the judge is telling the jury. I think difference between law and rule of law, I've explained, sir. Rule of law is a means, is a principle and a system to ensure there is no arbitrariness, no subjectivity, no personal role in governance. That governance is based on established, organized principles and systems, and whereas law is, we have already explained that law is basically a hypothetical fact pattern which has been laid out or prohibited in order to uphold the values of right conduct, which are what constitute justice. Logical reasoning I've explained. Now court management, I'll finally talk about that a little bit, sir. On court management, I was the initiator, the founder, chairperson for several years of the National Court Management Systems Committee because of Justice Kapadia when he was Chief Justice of the High Court. He established it. And I made a proposal to him and he established it and he appointed me to that role. Now, what we have done is if you go to the Supreme Court, so this requires a very long session, sir, but if you go to the Supreme Court and website and go under publications, you'll find a link called NCMS, National Court Management Systems Committee. And if you click on that, you'll find baseline papers on several fundamental areas of court management. And that includes also court management itself. These have all been written by committees headed by then senior High Court judges, some of who, for example, on court management are now in the Supreme Court. For example, the report on court management was written by Justice Khanvilkar when he was an honorable judge of the Bombay High Court. An outstanding report with a committee of judges helping him. And it is on the website. It is publicly available to also judges in other countries. These are non-binding standards that we have established and not established, sorry, we have formulated as suggestions and as for consideration by courts and judges. So there are various aspects of court management on which there are detailed background papers. Please read them in detail. Now, I will make just 2 points. The problem with court management is the lack of performance standards on quality, on responsiveness, on timeliness, on efficiency. The big difference between the Indian judicial system and the Western judicial systems is that they have performance standards. And this is why we created NCMS and we created these model performance standards. Now, what each of the honorable judges here can do, your presiding officers over your own court. There are many judges in the Supreme Court who may not have presided over a court, but even the junior division judge here presides over his court. And so you have the right and the power, with the approval of your senior judges, your chief judicial magistrate, and through him of other senior judges, but suggesting to them of how you can establish, based on the NCMS documents, some performance standards in public on timeliness, on efficiency, taking into account your own constraints, on prioritization. Will you prioritize on the basis of first come, first served, or will you prioritize on the basis of the urgency and of the injustice that people are suffering from? There are different ways. You'll see this discussed. But how will you prioritize cases within your constraints? How will you list them? How will you ensure that a plan is made for each trial in consultation with the lawyers, the handful of lawyers who work in your court, who handle most of the work? And if you look at these papers on NCMS committee, you will see a description of the special list system in the Kerala courts, the Kerala district judiciary, which is followed for civil courts. And the special list system is a system whereby a list is made in advance a few months before the date by the courts, by the district courts. Kerala has a very high caseload. Kerala and Tamil Nadu have virtually the same caseload, although Kerala has, less than half the population of Tamil Nadu, because there's a very high filing of cases by courts. And actually, if you go to National Judicial Data Grid, you will find that the cases that are over 3 years old are substantially less in Kerala than in other parts of the country. If you look at the percentage of cases which are delayed, much less in Kerala, although Kerala has the highest caseload of all the courts in the country in terms of per judge caseload. Why do they do it? Because they're more structured in their reasoning, in their functioning. So the special list system is a system where a presiding officer will identify which of the cases in his or her portfolio are mature and ripe for trial. Some may be new, some may be old, but looking at all the problems and will identify them. And then will actually assign, talk to the lawyers concerned or tentatively assign the dates for the trial of those cases that are ripe for trial. Post it on the notice board. Lawyers can come and say, okay, I'm actually, my uncle may get sick that day, or, I don't know, so something unpredictable will happen. So I don't want that day. Fine, change that day. So finally, the list is finalized. That list is then sent, a copy is posted on the board, sent to Advocate Bar Association, shared with law clerks, sent to the High Court. And once those dates are fixed, they're sacred. They cannot be changed. They can be changed, not legally, they can be changed, but it's taken as a very serious matter by the lawyers and by the judges. So the judges like it, lawyers like it, clients like it, because there's predictability. This is on the civil side. And as a result, the productivity and timeliness and the quality of justice has hugely improved. Now, I have been sharing this with judges, high courts across the country for years, but not a single other high court till today has adopted it. But there's nothing preventing the special list system being used by an individual presiding officer with the approval of his chief judicial magistrate or his principal district judge or the judge in charge of the high court, whoever. But if you go to that person and say, look, I would like to follow this system, let me at least try it, I'm sure it can be done. So we have within our country, we don't need to go to Singapore or United States, we have within our country systems that can be used to manage our courts better. So that's one particular specific suggestion I would give to you to manage the courts better. The second suggestion I would give to you is very important. Please think of your problems on court management as problems of court management, not problems of the judge. Because I have seen and studied courts, judges may come and go, but you know this very well, that a court has its own internal physics, Depending on where it is, the clerks are there forever, the bar is there forever, the local touts are there forever. Each court has its own physics, the fundamental forces that make that court. So your challenge is not so much to improve your own management techniques, but to alter that physics. And to alter that physics, you need to understand that physics and get the other forces involved to persuade them to change. And so I would request you to talk about court management. A court is an institution. It is not an individual. I know that many judgments say the judge personifies the court. No, judge does not personify the court. The judge itself is a function. A court is an activity carried out in accordance with law that requires several functions, including a judge. But the judge has it's like an orchestra. The conductor has a very important role to play, to pick the music, to interpret the music. But ultimately, if the conductor stands alone, he cannot play any music. Everyone has to work together to produce good music. A court is like that. So what I would say is, please think of, if you have presided over a court and you are presiding over a court, please understand the problems of the institution, not just yourself, that I have too much work, the bar is not cooperating, the high court is not cooperating, the litigants are not cooperating. This is a very judge-centered approach to the problems of the court. Please understand, including the judge's problems, also the problems of the bar, the staff, the litigants, all of this into account. Understand where you stand now, and then develop a 5-year plan to improve Identify the performance parameters of the court and develop a 5-year plan to improve the performance of your little court. If you're in a small court in a small town, try to get a vision. It may be a very small vision. It may not succeed it will not succeed in solving all the problems, but let us move forward in some direction, in some kind of organized manner, and let people care for institutions and not just for just the bar. The bar will only talk of problems of the bar. The judge will only talk of problems of the judge. To my experience, the staff are ones who talk more about the institutions than either the bar or the bench. The litigants only talk of their problems and nothing else. So who is going to sit everybody together, understand where we are in terms of our quality, responsiveness, access to justice, and how will we move forward, and develop a vision. And we have model court development plans on the NCMS website. Please look at that. Develop a court development plan for your court. Even after you leave, tell your successor that there is this plan, please support it and continue it. And let the judiciary play a role in gradually correcting the physics of courts and making them work better. This is my second point. And on court management, that there are two techniques you can use. One is a specialist system, and the second is a more comprehensive system to use court development plans, because frankly, like the judge honestly said, that there are no hard and fast rules on why people believe. There are no hard and fast rules on how to solve court management. But these are two methods you can use. The last point I will make, because I'm 12 minutes beyond my time, the last point I will make is that your biggest challenge facing the judicial system in the country, in addition to being more aware and more conscious in protecting the fundamental forces which operate through which the judicial system operates. The other very important issue in our country is access to justice. I have, through my research, created a concept called docket exclusion. When I went to NJA in 2006, everyone used to talk about docket explosion. Today, very few people talk about docket explosion. From Rashtrapati and Chief Justice of India downwards, number of people have used this term, which we coined docket exclusion. What is this docket exclusion? Docket exclusion looks at the number of new cases filed per 100,000 population in a jurisdiction. Laws create rights. As we have seen in the Evidence Act, rights, liabilities, right, and disabilities. Now, these rights, liabilities, and disabilities in the civil side are invoked by people. And on the criminal side, they are invoked by the state, except when there are private complaints, but ultimately the state is the main prosecutor. So the number of cases filed in each year provides an indication of whether or not these laws are actually, these rights, liabilities and disabilities are actually being effectively safeguarded and implemented and followed, because they are violated. When violation happens, they are laws only because they are not observed in normal conduct. We don't have a law saying you shall breathe, because everyone breathes. But we have a law now, or a rule saying you shall wear a mask, because people don't wear masks. So it is only by looking at whether there is any enforcement of this or protection of rights that we know whether laws are being implemented. Now look at, therefore, the number of new cases per 100,000 population. Globally, let's look at United States, 340 million people, 100 million new cases a year. That's about 340 new cases per 100,000 people. In Europe, it's about 200 new cases per 100,000 people. In Singapore, it's about 100 new cases per 100,000 people. In Delhi, it's about 55 new cases. In Kerala, it's about 50 new cases, 40 to 50 new cases. In Bihar and Jharkhand, it is 3 new cases per 100,000 population. If you file a new case against somebody, you're going to get attacked. So the poor people are docket excluded. I ask judges, what's a court? They tell me it's a temple of justice. I asked a poor Dalit in Madhya Pradesh when I lived there, what is a court? And he told me, sir, a court in Hindi, a court is a place that the police forcibly takes you to be punished, even if you have done nothing wrong. Blaming the police, not the judge. In fact, they were not even aware that there is something called a judge. When I explained to them, you've been punished, you got it. Then they said, oh, you mean the police officers who wear black robes? We know there are two kinds of police officers. Some wear khaki, some wear black. The black dress wearing police officers rarely talk to us. They rarely smile. They rarely acknowledge us. They don't even look at us. Police walas harass us, they take bribes, they beat us, but there are some police walas who are humane and talk to us, understand our difficulties. But these black uniform police walas, sir, they are very, very frightening. Now, when will somebody tell me, when I walk into a village in Maharashtra, that a court is a place where poor people go to protect themselves and their rights from the powerful people? That's the definition of a court. It's an institution where we get protection and our rights get protection. That day will come, thanks to the effort of people like Mr. Gogane and Mr. Sudhakar and all these others. That day will come, but I hope it comes quickly and not and not very late. My mind goes to an article written by Mr. K. Abbas, famous filmmaker. When he was a little boy, Mahatma Gandhi visited his village and met with the villagers. And in the audience was an old weaver woman, W-E-A-V-E-R, weaver woman, who was very, very poor. And Gandhi told them that we were fighting for Swaraj. Described Swaraj. He said, you will exercise power. That is what is Swaraj, not the elite people and powerful people. He described Swaraj. And then he showed the charkha and said, this is the instrument through which we will win Swaraj. And Abbas says this woman smiled because she knew that she was a weaver woman. She knew the charkha better than Gandhi did. So she was happy that they're using a weapon. He said, this is the weapon through which we will get justice. A weapon that was her own weapon, a weapon of peace, a weapon that makes and not destroys. Then Abbas says, she gave everything she had. She went to a hut, came back, everything she had, she gave to Gandhi. And then he says, she asked Gandhi a question. She said, Bapu, when will the Swaraj come? Will it come in my lifetime? This is why we have the Indian state today, a democratic republic, to give her the Swaraj that was promised to her. Very late, well after her lifetime, but maybe better late than never. So I think this requires for us to rethink some of these ideas that we have and to understand justice in a new way, to understand securing justice in a new way, to understand quality in a new way, responsiveness in a new way, timeliness in a new way, and efficiency in a new way. So that I think the dream that is in the preamble will be realized. Let me stop here, sir.
Sir, if you permit two small questions, sir.
Yes, sir. Yes, sir.
They are pertaining to the jury system. I will put them in one go.
Yes, sir.
First is one respected judge participant feels that in that jury trial which we discussed, probably the jury members were swayed by the public perception, media, etc., etc. One
Yes,
thing.
yes, yes.
So related question put up by another participant is that how these jury members were selected.
Yes, sir.
And another particular question from our Honorable Justice from Sri Lanka is that in in USA, that is a 12 judge. How this 12 judge? Why this 12 judge number is selected for
Yes,
jury?
yes,
And
yes.
one more is in Sri Lanka, if the verdict is of if the jury is 7 members, and
Yes.
if the verdict is by 5:2 or 6:1, they are accepted.
Yes,
If it is 4:3, verdicts are not accepted and sent for reconsideration or for first trial.
Yes,
So
sir.
you wanted to know that how was it in India when it was there?
Sir, can I request you to answer that last part, sir, first, and then I will come to the other parts. How was it in India when it was there, sir?
So it was actually no, sir.
You had it in Bombay, so you know it better than me, sir.
No, sir. I did not study the number system at that time.
Yes, sir.
They
Yes,
were
sir.
selected, and because it was borrowed from the England, sir, the same was
Yes,
followed.
yes, yes. Yes,
And
sir.
sir, you have already said that when the it is not accepted, it is remanded or sent back for first trial.
Yes, yes, sir.
One question related was what would be the relevance or value of that evidence earlier taken?
Yes, sir. No, that is very simple, sir. That completely fresh trial. No relevance to the previous. Previous the previous trial dies. Sir, the answer to why 12, sir, what historians say is that we have 12 people because it started in 8th century AD, sir. A king of Wales established jury trials in the 8th century AD, and he decided upon the number linking the judge and the jury to Jesus and the 12 apostles of Jesus. Judge like Jesus, and the 12 apostles, the jury like the 12 apostles. So at that time, in 800 AD, that was just around the time the prophet was born, sir. Around that period, that was the period, very long time ago. So it is, it is in that time. They decided the 12 number based on this. That is what we know. That's what some scholars have argued. That is why there are 12 jurors. And also, this even number does not matter because you need unanimity. You need to convict, you need unanimity. One person alone can prevent the conviction, one person. And that, sir, later after the 8th century, you've seen the Magna Carta, sir. The Magna Carta, as you know, says that talks about the right to be judged by my peers as a very fundamental principle, that the king will not judge me, that I will be judged by my peers. And so this grew into a very, very fundamental, fierce, a very fierce principle enacted in the 13th century. That is 500 years after this jury system began. So in those 500 years, it got a lot of acceptance. And people demanded that we don't want the jury to judge us. So today, sir, frankly, if you ask me, I agree with jury prejudice and jury, jury, all the concerns that were expressed by the Honorable Judge. He's right. But today it is not that people say we want jury. They're saying we do not want to be judged by a judge. We do not want to be judged by an official or by the king. So the Magna Carta says we want to be judged by our peers, not by the king, as a principle of democracy, because king should not have power to judge us. So it's a question of distribution of democratic power. When the judge judges me, then the power is with the state, not with the people. So we have to democratize. One of my big concerns, sir, is we have to democratize the Indian judicial system from this Raja and Raj past. Because neither believed in democracy. The Raj believed in some of the principles of rule of law and so on and so forth, but minus democracy. And minus Swaraj, our right to rule ourselves. So I think, sir, the question is in the negative. We do not want, because, sir, if the judges were, sir, many judges have openly expressed concern about media trials. Why are we concerned about media trials, sir? Because we are afraid of its impact on the judge. Because the judge is not insulated from it. What is the problem in media trial? So therefore, to insulate against those problems are human problems, not judge problems or jury problems being influenced. And therefore, we have to have a structural response to that, to have 12 human beings unanimously accept some evidence as being beyond all reasonable doubt is safer than not. Even with that system, sir, even with that system, many people are being wrongly convicted, even with that safeguard. There is a university-based project in the United States called Project Innocence. Very successful program for many years. They are investigating claims of false prosecution and, false conviction. And they have identified many cases where the conviction was wrongly made and convictions have been reversed, have been set aside, not reversed, set aside. And some cases there have been new trials, and some cases the state has said, fine, we accept, the prosecutors have said we are not going to prosecute. The verdict cannot be changed. But you can declare a mistrial and disregard it. So I think, yes, these are not perfect systems, sir. So the Bible says, judge not, for you shall be judged. So basically the message is, judging people is not a good thing to do. That's why some religions believe that let us leave judging to God. Human beings should not judge each other. Judge in the sense of judgment as a basis of punishment, not judge for other on the civil side or have such, but you should not impose punishment on the basis of human judgment. Leave that to God to judge and punish. Punishment is something human beings cannot do. Gandhi himself had that view, sir, that humans have no capacity to know the full truth and therefore we have no capacity to punish. He was against punishment. Now there are many people who say it was impractical, but conceptually, and therefore it's not implemented. Conceptually, we are trying to find ways around it. But the fact of the matter is, sir, that we do not have the capacity to know the truth. We don't, and we never will. We can use the best possible systems. There we can improve the systems we now use. Are they foolproof? No. Are they much better than what we now have? Yes, they will be much better than what we now have. But will they still result in injustice? Yes, it will. And we will still keep trying to improve the system and not accept a bad system for what it is. So this is all part of, sir, our attempt to keep improving. The whole purpose of our independence, sir, and having our own government and Swaraj is that we have the freedom to improve our own condition in our own way without someone ruling us. So that's what we should focus on doing, all of us.
Sir, thank you very much. Most of the questions have been covered.
Yes, sir. Let me see, sir, if I have... on compassion, there were 3 or 4 questions, but I've explained, sir, that I see compassion as integrated into fraternity, and I see compassion as being this compassion of we the people, not of the individual judge. And yes, sir. So that I think may I request that there's anyone who feels any question has not been answered may send a message immediately. And
sir, earlier we have stopped the question answer. Now it is again open for last questions, if remain. But sir, most of the questions are relevant to the topic, today's topic, have been taken up, sir.
Yes. Sir, then can I just conclude by just putting on the screen, sir, the judgment of Justice Ravindra Bhatt, because it is a very important judgment that changes our concept of one part of the Constitution. One part is governance. but
Yes,
the Grundnorm part of the Constitution.
please, sir.
And with your permission, sir, if you
Sir,
permit
please,
me,
sir. Please, sir.
I will just take 1 second, sir. Yes, here it is. Has it come, sir?
Just 1 minute, 1 second, sir. Yes.
It is, yes, it's got red line. Yes, sir. Sir,
Yes.
I'd like to just look at para 14. This is the judgment of Justice Ravindra Bhatt of the Supreme Court of India. It's a larger bench, but it is his judgment. It's a concurring judgment by him. Prithviraj Chauhan versus Union of India, 10th February 2020. I know that some of the participants have already identified it, but I just want to read together, all of us, paragraph, 1 or 2 of these paragraphs. The Constitution of India is described variously. This is what I was repeating. The Constitution of India is described variously as a charter of the Republic, as charter of governance of the Republic, as a delineation of the powers of the state in its various manifestations vis-a-vis inalienable liberties, and a document delimiting rights and responsibilities of the Union and its constituent states. Then comes the sentence. Yes, it is all that. That is the governance part of the Constitution, but it is more. It is more. It is also a pact, an agreement between people about the relationships that they guarantee to each other. Apart from the guarantee of liberties of the state, that they guarantee to each other in what was once a society riven along caste and sectarian divisions. He's identifying the dangers, sir. We are riven by caste and sectarian divisions. Unless we have a method to overcome that, this is now me speaking, we are in danger. So he says that is why the preambular assurance that the Republic would be one which guarantees to its people liberties, dignity, equality of status and opportunity and fraternity. The 4 core ideas that are values of the 4 standards of human conduct, which are fundamental to the constitutional vision of justice. It is this idea of India, a promise of oneness of and for all people, regardless of caste, gender, place of birth, religion, and other divisions, that Part 3 articulates in 4 salient provisions, 15, 17, 23, and 24, right, sir? The making of the provision, this provision and others, in my view, is impelled by the trinity of the preambular vision that the constitution makers gave to this country. Paeans, praises have been sung about the importance of liberty, its manifest articulation in the original 7 lambs, that is freedoms, under Article 19 of the Constitution, the other rights to religion, religious denomination, etc. Likewise, the centrality of equality as an important constitutional provision has been emphasized, and its many dimensions have been commented upon. However, the articulation of fraternity as a constitutional value has lamentably been largely undeveloped. In my opinion, all 3, liberty, equality, and fraternity, are intimately linked. The right to equality without liberty or fraternity would be chimerical, as the concept presently known would be reduced to equality among equals, in every manner a mere husk of the grand vision of the Constitution. Likewise, liberty without equality or fraternity can well result in the perpetuation of existing inequalities, and worse, result in license to indulge in society's basest practices. It is fraternity, poignantly embedded through the provisions of Part 3, which assures true equality, where the state treats all alike, assures the benefits of growth and prosperity to all, with equal liberties to all, and what is more, which guarantees that every citizen treats every other citizen alike. When the framers of the Constitution began their daunting task, they had before them a formidable duty and a stupendous opportunity of forging a nation, of creating a nation out of several splintered sovereign states and city-states. We must remember, sir, in 47, I am from the princely state of Travancore. Sovereignty came back to Travancore, sir, in 1947. I was part of a separate country from you, sir, in 47. And what happened in 1950 was I was restored to my country by the Constitution. Otherwise, the prince who ruled here took me away from India in 1947, and in fact toyed with the idea of creating a separate country and not joining India. What they envisioned was a common charter of governance and equally a charter for the people. The placement of the concept of fraternity in this context was neither an accident nor an idealized emulation of Western notion of fraternity, which finds vision in the French and American constitutions and charters of independence. It was a unique and poignant reminder of a society divided, riven with acute inequalities. More specifically, the practice of caste discrimination in its virulent form, where the essential humanity of a large mass of people was denied by society through untouchability. The resolve to rid society of these millennial practices, consigning a large segment of humanity to the eternal bondage of the most menial avocations, creating inflexible social barriers, was criticized by many sages and saints. Kabir, the great saint poet, for instance, in his composition remarked, and I will end with this, he says, if you think as the maker distinguished castes, that birth is according to these penalties for deeds, that you're born a Shudra and you die a Shudra, it is only this world of illusion that you assume the sacred thread. If birth from a Brahmin makes you a Brahmin, why do you not come by another way? If birth from a Turk makes you a Turk, why were you not circumscribed in the womb? This is the Supreme Court of India speaking, sir, in its judgment. So I want to say, sir, to show that much of what I have said in these 2 days, I've drawn from the Supreme Court, sir. It is not just my personal view. And I think we should understand that the most important values are fraternity, equality, and liberty. That justice means fraternity, equality, and liberty, and dignity. Which that unless these values are upheld, we don't have justice. And I hope that the 4 fundamental forces that uphold the justice system will be strengthened and held firm by the honorable judges. Thank you very much, sir, and apologies for spilling over by half an hour of the time.
No, sir, it is our pleasure, sir. It's not just one Gogne or one Mr. Adlagadda. Sir, there are many more persons in the participants. I can just assure you, sir, by telling that at this moment, still there are near about 770 participants attentively attending the session, sir.
I'm very grateful to you and to them.
Sir,
my intention is only to serve them, sir, serve all of you, which I've done for the last many years, sir, to serve the judicial system independently and to help to take forward the vision of a democratic, new, reformed system of governance in our country.
And many requests have been received to arrange such sessions. So I can make this request with the figures of this attendance what I have now quoted, sir. That is how we eagerly want to learn. What happens, sir, after working for so many years, not only about the newcomers, after working for so many years, I take for my example, I think that I have become perfect something in doing a thing. I'm doing it very well. I have understood the law. I'm doing very well. But these trainings are, sir, as you also say, this is a part, this includes unlearning also. Unlearning. Until now, we have been understanding the law and implementing the law accordingly as per our understanding. The moment we come to know that no, that is not the correct meaning, concept of the law and justice, then we will start doing that. This is a part of unlearning also, sir. And with your visionary words, and sir, we have since yesterday, you have covered how to secure justice, how do we understand the constitution, how do we understand the rule of law, how do we understand the justice, how do we understand the reasoning, and which included logic, discretion, etc. And today you have dealt with the important topics of securing justice, institutionalizing, that is quality responsiveness, timeliness, and quality and responsiveness, timeliness and efficiency. So very wonderful sessions, just like Tirath Nahaye, Ganga Nahaye, just like that, sir. And I, on behalf of all the participants, I express my gratitude to you, sir. I run short of words to express this my vote of thanks. Very thank you, sir.
Sir, I'm also very grateful to you, sir, and inspired by the amount of work you put into all this, sir, organizing all these programs and participating in them, commenting on them, supporting them. I mean, you came online early in the morning today to make sure that today everything was perfectly done. Inspiring, sir. Thank you very much for your own efforts. I'm very grateful to you.
Sir, I on behalf of Maharashtra Judicial Academy, I express my greatest thanks with all humbleness to the Honorable Justices of Sri Lanka and Nepal and Honorable Directors of their academies and all their Honorable Justice and Judicial Officers who have keenly attended these today's sessions. I express my gratitude to all of you, sir. I also express my gratitude to all the principal district judges, principal judges, honorable registrars of the High Courts, registrars generals of the High Court, and the family court judges, and especially to the directors and their colleagues of all state judicial academies of India, sir. Sir, almost all state judges have attended this.
Wonderful, sir.
And I express my deep gratitude, and I request for further kind of similar coordination, collaboration for similar kind of sessions. I also express my special thanks to our Honorable High Court Chief Justice Deepankar Datta sir, our chairman of our academy, and our Honorable Officiating Director Sri Justice R.D. Dhanuka sir, and all our honorable judges who encourage this kind of workshops for the benefit of the all. I also express my special thanks to our team, the collaborating team from the SCC Online, Chetan Singh Sergil. Sorry, you have been consistently with us to ensure that the program runs smoothly. And I also express my special thanks to the SCC Online management, Mr. Kapoor, Mr. Malik, both Maliks, and Sri Sanjay Kapoor. And I express my special thanks to the public prosecutors, the principal magistrates, and the social work members of the juvenile justice boards, the law students, and the staff members also who have eagerly and interestedly attended these webinars, and they will carry forward these learnings. So with this, I conclude this session with again one more thanks to my team members, my colleagues here at the academy, Mr. Thorat, Akash Thorat. He has been along with me for all the while, and my deputy director, Mr. Singhel, and our additional directors, Mr. and Mrs. Jamadar. And with this, with kind permission, sir, I will conclude this.
Yes, sir. Thank you very much.
Chetanji, thank you very much.
Thank you, Mr. Gill, for all your help and assistance.
So the recording would be available today itself in the evening. So I will be sharing the link with Yelagra, sir. And I think the same would be updated on the Maharashtra Judicial Academy, sir.
Yes, sir. So maybe at the cost of repetition, I would like to inform all the participants that by clicking the same links provided for accessing yesterday's and today's, the participants can watch the recorded video, and after receiving the link from the SCC Online, we will make them available on the YouTube also. Till then, you can access them through the same link. Am I right, sir?
Sir, certainly, sir. Yes.
Thank you very much. We will meet again. Thank you very much. Good day, sir.